Item 3 of supplementary list judgment.
You sign in. The writ appeal and WBC number 380 of 2023 are allowed and disposed of recording.
Biblio.
This one date. Signature will do afterwards. You want to sign now?
Item 1 and 2 of daily list admission.
No. My Lord, with great respect, my Lord, I'll do my best level to convince you, Lord. I'll do my best. And I won't take time also, my Lord. I'll confine to a short perimeter. Lord, last occasion, my Lord, I have submitted to your Lordship that, my Lord. To read petition, your Lordship. There are two read petition, my Lord. There are the two read petition, my Lord. And this is the judgment consisting of that two read petition. One was filed by the Manipur Hockey and another was filed by the Hockey Manipur. And then 916 of 2019 was filed by the Manipur Hockey. And then writ petition, your Lordship, 7/24/2019 was filed by me to implementing the implement order to the
You are Hockey Manipur.
my Lord, I am Hockey Manipur. No, my Lord, we go to page 36 of Memo of Appeal of 27 of 2023 Gower people. There are two read appeal, my Lord. One is 27 of 23 and another is 28 of 2023. Now your Lordship has 27 of 2023. And then I would go to your Lordship that page 36.
It's 36.
My Lord. The prayer, my Lord.
1 minute.
The prayer met in the writ petition C number 916 of 2019, my Lord.
Page 36.
Page 66. Now there are two primary prayers.
1 minute.
Page 66 of the Memo of Appeal of the writ appeal number 27 of 2023.
Yeah.
Lordship God.
Oh.
Now prayer number C, your Lordship. To issue a writ in the nature of certiorari for quashing the order bearing number dated 22/1/2018, issued by the Secretary Corporation Government of Manipur, directing the petitioner to change its name and alter its memorandum within 3 months from the date of the receipt of the order. And prayer number D, to issue a further writ in the nature of the mandamus, directing the respondent number 1 and 2 to consider and dispose of the representation dated 29/12/2017. Now we have to go the 22/1/2018. That is page 152 of the Memo of Appeal. The first prayer, my Lord, praying for quashing the government order dated 22/1/2018, page 152. Your Lordship, kindly have the page 152, my lord. No, my lord, let me read, my lord, this is very short. Whereas certificate of registration of the society under the Manipur Society Registration Act 1989, dated 12th November 2009, issued by Registered of Society Manipur in respect of Manipur Hockey writ as under. It is hereby certified that Manipur Hockey, having its registered address at Imphal, has been registered under Section 7(1) of the Manipur Society Registration Act 1989, bearing registration number 402 MSR 2009. Whereas the certificate of registration of an amalgamated society under the Manipur Society Registration Act 1989, 21/1/2010 in respect of the Hockey Manipur writ is under. It is hereby certified that pursuant to Section 12 of the Manipur Society Registration Act 1989, the society is hitherto called Manipur Women's Hockey Society, registration number 94 of 1976, dated the 26th October 1976, have been amalgamated into one society in the name of the Hockey Manipur. Kuman Lampak Imphal is with reference to the proceeding of the joint general body meeting of the two associations held on 18 October 2009, dated the 21st January 2010, has been allotted to the society. Whereas Section 10 of the Manipur Society Registration Act 1989 lays down as under. 10. Name of the society. No society shall be registered under a name which is identical with or too nearly resembles the names of any other society or any body corporate which has been previously registered or incorporated under this act or in other law for the time being enforced, as the case may be, or is deemed to have been registered under this act. And whereas Section 11 of the Manipur Society Registration Act 1989 lays down as under. State government may direct change of name if a society is registered under a name or alter its name to another name which is to the opinion of the state government is identical with or too nearly resembles the name of any other society or body corporate which have been previously registered or incorporated under the act or any other law for the first time being in force or next page, my lord, being deemed to have been registered under this act continue to exist. The state government may, by order made in this behalf, direct such society to change its name and alter its memorandum within 3 months from the date of the order on such longer period as the state government may think fit to allow. And whereas on perusal of the examining the above two certificate manually, it is fully convinced that when the following two societies called under the name of the style Manipur Women Hockey Association, register number 1994 of 1976, dated the 23rd October 1976, and Manipur Hockey Association registered number 2002 of 1976, dated the 26th October 1970s, are already existed registered society. Registration of a similar society under the name and the style of Manipur Hockey on 12/11/2009. It is clear violation of the Section 10 of the Manipur Society Registration Act 1989. Now, therefore, after due consideration of the aforesaid facts, I, Shri M. Joy Singh, IAS Secretary Corporation Government of Manipur, is exercise of the power conferred upon me under Section 11 of the MSR Act 1989 and rules number 14 of sub rule 9 of MSR rules 2004, do hereby direct Manipur Hockey to change its name and alter its memorandum within 3 months from the date of receipt of this order. This is agreed by the petitioners, Manipur Hockey. How they agree, my lord? After reading this impugn order one, my lord, we can understand then there is a true provision. Because registration of the Manipur Hockey is emanated from Section 7(1). And the Hockey Manipur is the amalgamated body, and the my lord re-allotted the numbers, registration number. And it is output of the two associations, namely Manipur Hockey Association and the Manipur Women Hockey Association, registered in 1976. So, my lord, this registration certificate was emanated from section, no, section 12. So therefore, there is two sources of law for registration. Lord, let me refer to the no registration. Lord, Lordship may kindly see the people. There are two sources of law, my lord. There were registering the Manipur hockey and thereby reallocated the numbers, registration numbers of the hockey Manipur. That let me refer to the relevant section of the Manipur Society Registration Act 1989 and rule frame there and there. My lord, first, my lord, let me read, my lord, section 7. Section 7, my lord. Section 7, my lord. The registered, upon being satisfied that the memorandum and the regulation accompanying, my lord, this is act. My lord. Registered upon being satisfied that the memorandum and the regulation accompanying it complied with the requirement of this so and so rule upon payment of the fee referred to in subsection 2 shall certified under this and shall that society is registered under this act. There shall be paid of so and so. This is the, my lord, registration, newly registration by invoking section 7. And rules friend there under, my lord. Read with rules. Rule 5. Rule 2. And rule 5. This is the very section registering the Manipur hockey, your lordship. Rules, section 7, read with rule 5. Read with rule 5, my lord. Rule 5, my lord. It talks about, my lord, application for registration under section 7. An application for registration of the society, so there are so many conditions, as your lordship knows, because your lordship has the act and rules. This is the very source of power, source of law, thereby registering the Manipur hockey. Now, my lord, in respect of the hockey Manipur, my lord, let me refer to section 12. Section 12. Section 12, my lord. Society to have power to amalgamate with another society. Read with rule 15. Procedure to amalgamate with another society under section 12. These are the relevant sections and rules, thereby registering the Manipur hockey and thereby reallocated the numbers of the hockey Manipur. Now, the registration was in respect of the Manipur hockey 2009, new registration. And in respect of the Manipur hockey, after amalgamation and the output of the two associations registered in 1976 was registered in 2010. Now, here in this case, my lord, section 10 has been referred by the state of Manipur, my lord, commissioner. Now, what about section 10, my lord? Let me refer to the section 10. Section 10, my lord. A society shall be registered under the name which is identical. No society shall be registered under a name which is identical with or too nearly resembles the name of any other society or any body corporate which has been previously registered or incorporated under this act or an other law for the time being in force as the case may be or is deemed to have been registered under this act. Relevant? No. Relevant rule. Rule 30. Read with rule 30. My lord, let me refer to the rule 30. Similar or nearly similar names and identical under section 10. These are the procedure to be followed of the section 10. Now let me refer to the documents, my lord. My lord, certificate of the, your lordship may kindly say, certificate of the Manipur hockey. Registered certificate, my lord. Refer page 94. Page 94.
90.
94, my lord, in the memo of appeal. It is hereby certified the Manipur Hockey having its register address at Imphal has been registered under Section 7(1) of the Manipur Society Registration Act, bearing number so and so, so and so, given under my seal and so and so, so and so, so and so. It was issued by the Register of Society on 12 November 2009. Now again, let me refer to the another certificate issued in respect of the Hockey Manipur. That page 108. Page 108. The registration certificate in respect of the Manipur Hockey was issued under Section 7(1) of the Society Registration Act 1989. And the rules framed hereunder. And then page 108. This is the registration certificate in respect of the Hockey Manipur, stating that, my lord, page 108, my lord, let me invite your lordship. Have to look, my lord. 108. It is hereby certified that, pursuant to Section 12 of the Manipur Society Registration 1989, the society dared to call Manipur Women Hockey Association Register number 1994 of 1976, dated the 23rd October 1976, and Manipur Hockey Association Register number 2002 of 1976, dated 26 October 1976, have been amalgamated into one society in the name of Hockey Manipur, Kumalampak, Imphal East, with reference to the proceeding of the joint general body meeting of the two associations held on the 18th October 2009, registration number so and so 21 January 2000 has been allotted to the society. That was on 21st January 2010. The central issue, one of the great issue raised before the learned single judge, is that registration certificate was issued in favor of the Manipur Hockey on 12 November 2009, and in respect of the Hockey Manipur 21 January 2010. Therefore, the Section 10 bar in issuing this certificate. It was the main contention before learned judge. Now, your lordship, if your lordship look at page 109. Page 109. It's a very important order. Consequent on the amalgamation of the Manipur Women Hockey Association, registration number 1994 of 1976, dated 23rd October 1976, and the Manipur Hockey Association registration number 2002 of 1976, dated 26 October 1976, under Section 12 of the Manipur Society Registration Act 1989, forming a new association in the name of the Hockey Manipur Kumal Lampak, Imphal, to which registration number 419 MSR 2010, dated 21st January 2010, has been allotted. I, Thang Thueling Pamay, Register of Society of Manipur, in exercise of the power conferred under Section 12B of the Manipur Society Registration Act 1980, with Rule 15(8) of the Manipur Society Registration Rule 2004, do hereby cancel. Now, what is the cancel? These two associations. The first association, Manipur Hockey Association, and the Manipur Women Hockey Association, which were registered in 1976, has been cancelled. When it was cancelled? Only on 25 January 2010. And registration number allotted to the aforesaid two society with immediate effect. That is on 21st January 2010. Meaning thereby, my lord, up to 21st January 2010, two associations were exist. So therefore, this registration certificate in the name of the Manipur Hockey is barred by Section 10. That was the conclusion and finding of the learned single judge. Because the identically nearly resemblance two associations were very much exist, only when its non-existence was only 21st January 2010, wherein the two association certificate was cancelled. This very fact has been elaborately stated in the counter affidavit filed by the government that has not been controverted by the petition before the learned single. That has not been, they have not even filed a rejoinder affidavit. They admitted everything. This is the very fact. This is the central issue. So therefore, the learned single judge came to the conclusion that no, you cannot register. Instead, the learned single judge directing to the Manipur hockey, then you have to change your memorandum and name instead of cancelling. They are very lucky. This is the crux of the issue. So therefore, my lord, this is the first point. This is the first point. The two associations existed up to 21st January 2010. That was registered in 1976. And Manipur hockey was the output of the hockey. Manipur is the output of the two associations. And two association was cancelled 21st January 2010. And the certificate of the Manipur hockey was issued on 12 November 2009. Wherein, my lord, the two association was very much exist. Therefore, the section 10s come into play. So therefore, your lordship, if I straightway go to the counter affidavit by the government, your lordship elaborately stated, with the permission, let me refer to the counter affidavit. Let me refer to the counter affidavit, my lord. That is, your lordship, can you see counter affidavit? Page 169. After reading this counter, very short and very precise and very elaborate, my lord. And commissioner and the my lord registered have filed the counter affidavit. Start from my lord, page 172, consisting of some pages, my lord. It's not much pages. Page 172. Para 3. Your lordship got it. That before giving Parawa's reply to the contention and allegation made by the writ petitioner, in the writ petition, the deponent craves leave of the Honorable Court to state the following facts for better appreciation of the Honorable Court. On 23rd-10-1976, that is page 108, my lord, Manipur Women Hockey Association was registered, being registered number 1994 of 1976 under the Society Registration Act 1860. Similarly, on 26/10/1976, Manipur Hockey Association was also registered, being registration number so and so under the section so and so 1960. On 12/11/2009, this is the old act, my lord, which was registered in 1976, was prevailing this very act, and subsequently it has been amended. On 12/11/2009, the writ petitioners association, namely Manipur Hockey, was registered under section 7(1) of the Manipur Society Registration Act 1989, being registration number so and so. On 21st/1/2010, the earlier two societies, namely Manipur Women Hockey Association, registered number 1994 of 1976, dated 23/10/1976, and Manipur Hockey Association, registered number 2002 of 1976, dated 26/10/1976, have been amalgamated into one society in the name of Hockey Manipur. It is mine. It is mine, madam. The private respondent in the present case. Next page, madam. Under section 12 of the Manipur Society Registration 1989, allotted the registration number so and so on 21st/1/2010, that is page 108. The Manipur Society Registration Act 1989 was framed and published in the official gazette on 17/3/1990. Some of the provisions which are relevant for the adjudication of the present writ petition is reproduced herein below for better appreciation of the Honorable Court. Section 7, your lordship, is not required to look. Section 10, name of the society. No society shall be registered under the name which is identical with or too nearly resembles the name of any other society or any body corporate which has been previously registered or incorporated under this act or an other law for the time being in force, as the case may be or is deemed to have been registered under this act. Now, next page, my lord. Section 11 is the state is empowered to direct to the society to change the name and the my lord memorandum association that is speaks about section 11. Now section 12 and section 11, my lord, and now they have produced then, my lord, next page 175. Start from, my lord, section 12, society have power to amalgamate with another society. Then page, my lord, section 32, repeal and saving, my lord. And then, my lord, page 176, Roman 6, my lord, that it is submitted that when the Petitioners Association, namely Manipur Hockey, was registered on 12/11/2009, under register number 402M/SR 2009, the Manipur Hockey Association, registered on 2002 of 1976, continued to exist. As the said Manipur Hockey Association was amalgamated with Manipur Women Hockey Association, registration number 1994 of 1976, only on 21/1/2010. Therefore, the certificate of registration given to the Petitioners Association, namely Manipur Hockey, on 12/11/2009 under registration number 402/M/SR 2009 was against the section 10 of the Society Registration Act 1989. Accordingly, the state government, in exercise of the power conferred under section 11 of Manipur Society Registration Act 1989, read with Rule 14, Sub-Rule 9 of Manipur Society Registration Rules 2004, issued the order dated 22/1/2018. This is the impugned order in the writ petition, directing the Petition Association Manipur Hockey to change its name and alter its memorandum within 3 months from the date of receipt of the order. It's a very clear. Now, pairwise reply, my lord. This pairwise reply, my lord, is very elaborate. My lord, let me refer pairwise reply. 127, they don't have any, control for page 177, para 5. That with reference to para number 8 and 9 of the writ petition, the deponent begs to submit that when the Petitioners Association submitted its application to the respondent number 2 for registration of their association, namely Manipur Hockey, under the Manipur Society Registration Act 1989, the respondent number 2 and its official, through bona fide mistake, have not properly examined and verified the existence of the similar or nearly similar name of society which has been previously registered in the name of Manipur Hockey Association under registration number 2002 of 1976 on 26/10/1976, and as such the respondent number 2 granted the certificate of registration bearing 402/M/SR 2009 on 12/11/2009 in favor of the, my lord, appealant to the Petition Association. Therefore, it is submitted that the certificate of registration granted to the Petition Association on 12/11/2019 was against section 10 of the Manipur Society Registration Act 1989, and accordingly the state government, in exercise of the power conferred under section 11 of the Manipur Society Registration Act 1989, read with Rule number 14, Sub-Rule 9 of the Manipur Society Registration Rule 2004, issued the order dated 22/1/2018, thereby directing the present Petitioners Manipur Hockey to change its name and alter its memorandum with 3 months from the date of receipt of the order. Because this is, as lordship, to my understanding, this is a very, very, very important point. And then para number 6, that with reference to para 10 of the writ petition, the deponent begs to submit that the Hockey Manipur is formed under section 12 of the MSR Act 1989 by amalgamating the Manipur Hockey Association and Manipur Women Hockey Association on 21/1/2010. Next page, Miller. And as such, the aforesaid two amalgamated associations continue to exist till 21/2010. Just I have read it before, Lordship. One order which has been cancelled, the two associations only on 21/2010. Therefore, the certificate of registration granted to the Petition Association on 12/11/2009 was against section 10 of the MSR Act 1999. As such, the issuance of the order dated 22/1/2018 by the respondent number 1 is in compliance with the section 11 of the 1989 as well as Rule 14, Sub-Rule 9 of the Rules 2004. Next, para 7, Milo. that with reference to 11, 12, 13, 14, 15, and 16 of the writ petition, the deponent has no comment to offer as the same are matter of records. However, the better appreciation of the Honorable Court, the deponent begs to submit that the only issue which is to be considered and decided by the Honorable Court in the present case is as to whether the society can be registered under a name which is identical with or too nearly resembles the name of the any other society which has been previously registered under the MSR Act 1989 or not. Therefore, it is submitted that the recognition of the affiliation again granted by any other body to the petitioner association cannot be ground for continuance of certificate of registration granted to the petitioner association in the name of the Manipur Hockey. As such, the order dated so has been issued directing the petitioner's association to change. Because of the section 10 is very clear. It is the mandatory provision. This cannot be registered because if there be any identical and nearly resemblance, register society is already there, then one cannot be registered if there be an identical and the nearly resemblance, associations were there. That is the one of the important points which has been decided by the learned judgment. Now, para number 8. That with reference to para 17 and 18 of the writ petition, the deponent begs to submit that the order dated 2/10/2016 issued by the Principal Secretary Corporation gave an opportunity to both the stakeholder Manipur Hockey and Hockey Manipur to reconcile and came under the common banner within 6 months in the best interest, my lord, of the hockey game and players. This was issued in compliance of the Honorable High Court order dated 17/3/2016 passing WPC number 435 of 2010. The same order also dispose of the representation cooperative appeal number so and so. Now, my lord, these are the factual background which have been, written by the competent authority regarding the issuance of the first impugned order, my lord, challenging by the learned by the appellant before the learned judge. So therefore, the government saying that no, this registration, even if you have been registered in 2009, there are two associations registered in 1976, which is very identical and nearly resemblance, because these are all discipline of the hockey games, hockey discipline. Therefore, this cannot be registered. And the Manipur Hockey registered in 2010 is the amalgamated body and re-allotted the registration number. Therefore, there are two sources of law. One is emanated from Section 7(1), another is emanated from Section 12. So therefore, what the government counter affidavit is that the issuance of the impugned order, said to be impugned order, is on the basis of the law laid down in the society registration. So there is no any irregularity in issuing the impugned order. This is the answer of the government, and they have not been controversial before the learned judge. This is the first prayer made before the learned judge. This is the very answer. Now, second prayer, my lord, let me refer to the second prayer. Second prayer, your lordship may kindly see. To issue a further writ in the nature of mandamus directing the respondent number 1 and 2 to consider and dispose of representation dated 29/12/2017, submitted by the President Manipur Hockey. Now, my lord, what is the representation? Let me refer to page 146. This is the representation filed by the Manipur Hockey, my lord, on 29 December 2017. Relevant page, prayer portion is, my lord, 151 of the representation. Start from 146, and my lord, ending page is 151, prayer portion. Now, what they have prayed in the representation, my lord, let me read out with the permission of your lordship. In the facts and circumstances mentioned above, I am imploring your good self for directing the Hockey Manipur to change its name by invoking Section 11, my lord. Same. What they are thinking is that, my lord, they have already registered. Therefore, the Hockey Manipur is registered in 2010 and the Manipur Hockey is registered in 2009. So therefore, Section 10 can be invoked to the Hockey Manipur.
This
Forgetting,
representation is dated 29 December 2017,
my lord,
or the signature part is something else.
my lord, signature is something else.
So which one is the correct date?
My lord, His Lordship Honorable Justice Muralidhar referred this dated 29 December 2017, my lord. Yes, Your Lordship is right, but then I'm also thinking on it. But however, my lord, the Honorable Judge referred to the that. Therefore, I'm referring to Your Lordship. And then what they are saying is that I am imploring your good self for directing the Hockey Manipur to change its name by invoking Section 11. Now Manipur Hockey is applying Section 11 to Hockey Manipur because their registration was issued in 2009. And Manipur, Hockey Manipur registration is 2010. Forgetting about the earlier registration, identical and nearly resemblance, namely Manipur Hockey Association, Manipur Women Hockey Association. What the learned single says that no, you can't do it because there is already two associations. It was, cancelled in 2010 only when the registration certificate of the Hockey Manipur was issued. Now, further, my lord, as it is exactly similar to the name of the already registered society, it is referring to Manipur Hockey and Hockey Manipur. Manipur Hockey and failing which to cancel. My lord, the word very cancel is very important now. What they are praying is that cancellation of registration of the Hockey Manipur. The registration of the said Hockey Manipur in exercise with power of the Rule 49 of the Manipur Society registration, so and so, so and so. This is the prayer made in the representation made. Now let me refer to the finding of the direction of the learned judge. Page 3554. My memo of appeal, page 3554. My lord, there are 61 of the direction of the learned judge, my lord. Honorable learned judge. There are 61. Read petition C number 916 of 1919 is dismissed. Now it goes to show that this prayer has dismissed. Even cancellation, praying for cancellation of the registration of the Hockey Manipur has also been prayed in the representation. It has already been dismissed. Your Lordship. Now there's nothing remaining. Now, this is the prayer portion, and then, my lord, counter affidavit filed by the government, and the Section 10, Section 7, Section 11, and Section 12. The entire case involved Section 7, Section 10, Section 11, Section 12. These are to be considered. Now, my lord, my respected senior, my lord, last occasion, he argued on the basis of the amalgamation. Amalgamation proceeding was wrong, or it was totally contradictory to the, established or procedure laid down in the pertaining rules and the relevant section of the Society Registration Act and the rule frame thereof. Now, in that case, in the writ petition, my lord, from page 36 to page 66, is there any allegation regarding the illegality of the amalgamation proceeding of the Manipur Hockey? Nothing is there. No statement, nothing is there. So therefore, prayer is what? Prayer is the cancellation of the 22/1/2018, thereby directing Manipur Hockey to change your name and the Memorandum Association and to consider the representation. So there was nothing regarding the amalgamation proceeding challenging this and that. No whisper, no statement. Nothing is there. Now, my senior colleague has submitted before the court saying that there was a irregularity committed by the authority while making amalgamation proceeding of the two bodies thereby issuing the certificate of the hockey manipur. Was there any statement? Was there any allegation? Was there nothing? So now they can claim before the division bench, stating that these proceedings are illegal, these are irregularity. The Honorable Court Division Bench has jurisdiction to see correctness and legality of the judgment passed by the learned judge. Nothing is there. Second point. And third point, my lord, let me refer to the contention of the petitioner before the learned judge. They have stated their appeal. My lord, let me refer to the contention, my lord, of the appellant before the learned judge. That your lordship may kindly see page 18 of the interned page 18 of the memo of appeal. 3.1. There are 6 contention, my lord. Interned page 18. Nothing has been stated regarding the irregularity, illegalities of amalgamation proceeding, my lord. There are 6 contention. They the writ petition appellant contended that the appellant is the only body affiliated and recognized hockey in India, and who have been conducted tournament coaching camp at and different level in the state, and who profess to have been established with the objective of promoting, encouraging all-round development of the game of hockey in Manipur to hold inter-district and other state level tournament, to conduct courses for the courses of the training, etc., have not undertaken not a single activity word it names till that in pursuance of the objective for which it was established, registered except for next page, creating hurdles in the smooth functioning of the appellant society. In other words, document exists only in paper. Allegations are there are serious allegations are there, Miller. Then the writ petitioners appellant contended that the impugned order dated 22/1/2018 had been issued by the respondent number 1 in a very arbitrary and malified manner in the colorable exercise of power with an ulterior and the preconceived motive to cancel and then more than 8 years and then when the order for amalgamation of the said two society was issued, when the registration of the two society have been cancelled by the Register of Society. Now 3.3, that the writ petitioners appellant contended that the registration of Hockey Manipur under registration was allowed only on 21/1/2010, much later than the registration of the appellant, which was allowed on 12/11/2000. In view of this undisputed fact that, invocation of provision of the under Section 11 of the Manipur Society Register 1989 and Rule 14(9) of the Manipur Society Rules 2004 by the respondent number 1 against the appellant instead of against Hockey Manipur, that too by totally ignoring the application that 29/12/2017 submitted by the Manipur Hockey is very much arbitrary. Now next 4.3, that this is very general contention, and 3.5 also general contention, 3.6 is general contention. These are the only contention before the learned judge which they have stated in the writ appeal. These are the only contention before the learned single judge. Now, the very important points which I would like to place before Lordship is that my respected senior counsel last occasion reviewed on the basis of the additional affidavit. Stating that, my lord, if you also look back to order passed by your lordship, that is 12/10/2022. This is the additional affidavit heavily relied upon the appeal in Miller. If you also got it, that 12/10/2023.
12/10.
12/10/2023. Honorable Justice, Honorable Chief Justice, and Honorable Lordship, sitting division bench. Learned counsel representing the appellant, my good friend Besoji, submit that additional pleading is required to be filed on behalf of the appellant, and thus a short opportunity may be granted for this purpose. Mr. Atobo Kaidem, learned additional government advocate, Manipur, representing the respondent number 1 and 2, and Mr. So and Mr. So, respondent number 3, do not object to the prayer so made. Licit so. Now, my lord, we do agree to file the additional affidavit. But filing the additional facts, which was not considered before the learned judge, in respect of the law, one can brought into, or one can brought before the division bench, in respect of the facts, in respect of this document, which was not been placed before the learned single judge, cannot be placed before the division bench. However, my lord, if there be any pertinent this and that, then we do agree. But they do not file, they did not file the misapplication, allowing to file this affidavit. They did not done it. Therefore, this additional affidavit cannot be taken as a record of the division bench. No. To my understanding, I may be subject to correction, my lord. If there be no order allowing to place this very record before the division bench, it cannot be treated to be record of the division bench. Because your lordship may kindly see this judgment passed by the learned judge. That was on, my lord. (27 2022). The judgment passed by Honorable Justice Muralidhar was passed on 27 2022 in writ petition 916 of 2019 and 724 of 2019. Now, this additional affidavit annexing the documents produced by the appellant, my lord, that was through RTI, that was on 30th November 2023, and producing this document.
Where's the additional affidavit?
That is the additional affidavit, my lord.
Here.
Here, my lord. That must be here, my lord. Additional affidavit, my lord, on my record, 12 October 2023.
You have a copy.
It's in written.
It's in writ April 28.
12 October 2023. 28. That may be 28 of 2023. Not here, madam. This cannot be treated a record of the division bench because unless they file the miscellaneous application allowing to file this additional affidavit. Because what I'm saying, so my lord, order was passed on 27 2022. And then this record was received through RTI only on 30th January 2023. How this record can be brought to the division bench? This record was never been considered before the learned judge. In this regard, my lord, there are judgments which I am not required to place before your lordship. There are batteries of judgment. I'm going to place 2-3 judgments. Very important judgment. This cannot be. So therefore, the entire argument advanced by my good friend is on the basis of the amalgamation was irregular. It is contrary and contradictory and derogatory to the procedure laid down in the relevant section and rules. So whether it can be take cognizance of the on division bench, no. Now these are the contention which have been met in the writ appeal. Now, thereafter, my lord, this is the second writ petition filed by the no, this This is, my lord, this is the second writ petition. This is the second writ petition, my lord. The earlier writ petition was dismissed on the same issue. But that was dismissed on technical ground. That has been stated in the judgment of the learned judge. Now, my lord, that is, your lordship, page 154. Page 154 of the memo copy. or memo appeal, my lord. This writ petition was filed in 2018 by Manipur Hockey, the same appellant. And then Hockey Manipur was not arrayed at party response. And Honorable Justice Nobin passed order on 38/2019. And then, my lord, operative portion of the order, my lord, page 168. The same issue. Praying for cancellation of the order issued by the commissioner, thereby directing to change the name in the office memorandum. And parent 9. For the reason stated herein above, the court is of the view that instant writ petition has no substance for the reason of non-joinder of the necessary party and is accordingly dismissed as not maintainable. It is, however, open to the petition association to approach any appropriate forum, including this court. Therefore, by this direction, this writ petition, the writ petition, my lord, which was allowed by the Honorable Justice Muralidhar, was filed. This is the second writ petition. Now, my lord, the third submission, my lord. The learned senior advocate argued before lordship is that the first point is that amalgamation proceeding was irregular. It is derogatory to the procedure laid down in the rules and the act. Now, whether he can claim the amalgamation proceeding is illegal, if there is no statement, if there is no prayer, if there is nothing, little whisper regarding the amalgamation is illegal and arbitrary, nothing is there. Had it been mentioned in the writ petition, the learned judge passed order different. Nothing was there. So therefore, my lord, whole contention, whole the argument, last occasion, my lord, was answered, my lord. And para number, your lordship, is I submitted last occasion, my lord. Para number 56 of the judgment. What it talks about, my lord, talks about, my lord, it is true that Manipur Hockey has conducted many tournaments at different levels in the state, and equally, Hockey Manipur has also participated in various national and international level hockey matches. That is not the issue to be decided in the present petition. Therefore, this court has not delved into the issue qua conducting the tournament and participation of Hockey Manipur and Manipur Hockey at different level is to in the state. Once an identical name exists, whether a society association can be registered under the identical or too nearly resemble is the point to be considered in this case. In this regard, as stated supra in section 10 of the Act clearly prohibits registration of such society which is identical or with or too nearly resembles. It is the admitted case of the Manipur Hockey that at the time of its registration, Manipur Hockey Association and Manipur Hockey were in existence. So therefore, telling the story of the partition, because we have also outstanding player. And this very hockey discipline was formed in 1976 by the Manipur Hockey Association and Manipur Women's Hockey Association. This is the only amalgamated body, united body of the two body, namely Hockey Manipur. So they are claiming that they have produced so many international and national players and the state players. So those submission has been answered by this, para number 56. Now, my lord, let me refer to the judgment. Let me refer to the judgment of the learned judge, my lord. Para number 40. Para number 40, my lord. Para 40. Though Manipur Hockey was formed and registered in 12/11/2009, Hockey Manipur got registered subsequent to it on 21st/1/2010. Manipur Hockey themselves admitted that Hockey Manipur was formed by amalgamation of two oldest registered societies, namely Manipur Hockey Association and Manipur Women Hockey Association. In their writ petition, WPC number 916 of 2019, it has been stated as under that a special joint executive committee meeting of the Manipur Hockey Association and Manipur Women Hockey Association was held on 28/6/2009. And in the said special joint meeting, it was resolved inter alia that Manipur Hockey Association and Manipur Women Hockey Association be amalgamated into one unified body called Hockey Manipur in pursuance of the said resolution. An order dated 29/6/2009 was issued by the Secretary General of the Hockey Manipur to the effect that the two associations, Manipur Hockey Association and Manipur Women Hockey Association, is amalgamated and form an unified body called Hockey Manipur with the 21 Executive Council member is mentioned in the said order. That has been, because they have admitted that Manipur Hockey Manipur is the unified body of the two associations which were registered in 1976. Now, my lord, para 42. Then again, may I read to para 42 of the judgment. Though the registration of the Hockey Manipur was given on 21/1/2010, the process for amalgamation was started during June 2009. The very fact was also evident from the status report submitted by the registered society dated 14/1/2019. Because this is very important, my lord, because this 14/1/2019 is very important, and in this regard, my lord, I'm going to argue later on. Pursuant to the interim order dated 27/11/2018, passed by this court, WPC number 124 of 2018, for proper appreciation, the status report of the 14/1/2019 is extracted hereinunder. In compliance to the order of the Honorable High Court of Manipur dated 27/11/2018. What is 27/11/2018, my lord? Page 216. If you also look at page 216, my lord. This is the interim order of the Honorable Justice Nobin, page 216. Page 216, Lordship. It's the interim order of the Honorable Justice Nobin, dated 27/11/2018. Mr. So-and-so, by the instant writ petition, the Petition Association has pressed for issuing a writ of certiorari to quash and set aside the order dated 22/1/2018, my lord. The same order which have been, my lord, challenged before the Muralidhar and the appeal against this order, my lord, passed by the Commissioner, on the ground that it was issued in violation of the provision of Manipur Society Registration Act 1989. After going through the amendment in the petition, it appears that the issue in fact relates to the question as to whether the Manipur Hockey or Hockey Manipur will represent the state of Manipur in matter relating to the tournament of hockey. In other words, all are concerned with the welfare of development of the sports of hockey in Manipur. In view of the above, this court is of the view that before the next page, issue raised in this petition is decided by this court, let the registry of society examine and explore an amicable solution for having one association only for which the petitioner can appear before the registered society so that a common name like all Manipur Hockey Association can be found out. Let this matter on 11/12/2018 before the registered and the petitioner is directed to appear before it on the said. While considering the matter to find out an amicable solution, it is open to the registered society to invite the Hockey Manipur so that the issue can be resolved for once for all. After considering the view and the suggestion of all the parties, the registered society shall submit a report of this court on or before 16/1/2019. Then, my lord, what was the report? What was the report, my lord? Report, lordship may find 218. This report, pursuant to the interim order passed by the Honorable Court, it has not been challenged. It should have been challenged. If lordship look at page 219, it is a type copy. Let me read out. Status report of WPC number 124 of 2019 is per order dated 27/11/2018 of Honorable High Court of Manipur. Page 219, my lord. It is the report pursuant to the interim order passed by the Honorable Justice Nobin.
Just 1 minute.
Yes, ma'am. Stating that, my lord,
Yes.
stating that, my lord, in compliance of the order of the Honorable High Court of Manipur dated 27/11/2018, passed in WPC number 124 of 2018, Manipur Hockey versus State of Manipur and other, a meeting has been conducted on 17 December 2018, and both the parties came for the meeting, 9 members from Hockey Manipur and 2 members from Manipur Hockey. From our side, 9 members, on their side, 2 members. The 2 representatives from Manipur Hockey said that they will not be in a position to take any responsibilities, decision, and that the meeting be postponed. Because pursuant to the order, interim order passed by the Honorable Court, this was conducted by all the petitions. But what they are saying here in Milo, the Lord may find. However, as the representative from Hockey Manipur had come in full strength and also prior information about the meeting had been served to both meeting notice by letter number so-and-so, 124 of so-and-so, 10 December 2018. Manipur Hockey coming only at the time of the meeting seeking postponement is not acceptable to this office as it is a deliberate attempt to foil the meeting. Now, there are 2 parts, left side and right side. Hence, it may be stated that reconciliation looks not feasible at this juncture, and hence the following facts are stated as below for arriving at final solution. Now, left side, right side. As per instruction from Indian Olympic Association, IOA, the Manipur Hockey Association and Manipur Women Hockey Association got amalgamated. Hence, with this, the separate registration number of men's and women hockey, women done away with. Instruction from IOA which was given to form 1 game, 1 body on June 1, 2009. And as per the instruction, both the Manipur Hockey Association and the Manipur Women Hockey Association came to a conclusion for the formation of the Hockey Manipur. Amalgamated already in 2009 on 28 June, while the registration number was given on 21st January 2010 after following the process of process of registration, my lord. Now, my lord, right side, let me read out. This is in respect of the Manipur Hockey. What I am reading before lordship is this in respect of the Hockey Manipur. While the process being done for registration of 1 body, Manipur Hockey was given registration by the RCS on 12 November 2009, became an entirely new body with no representative from the previously existing bodies association, because that is 2 associations, Women Hockey Association and Manipur Hockey Association. There is no amalgamation as such. This is in respect of the Manipur Hockey, my lord. Only 5 days were given after the advertisement for registration of Manipur Hockey before the registration was done in violation of the rules 13 of the MSR Act 2004. Further, their notification was objected by the Secretary Hockey Manipur on 2 occasions. On 13 October 2009, that is before registration of the Manipur Hockey, we have filed application for objection not to register. Name is Manipur Hockey. That is 13 October 2009 and 6 November 2009, well ahead of the registration being issued on 12 November 2009. Accordingly, the Principal Secretary also deregistered Manipur Hockey. However, the same was withdrawn by the order of the Honorable High Court dated 31st 7 2017. The Secretary Corporation had also directed Manipur Hockey change its name on 22nd January 2016 within 3 months. But this order is stayed by the Honorable High Court of Manipur order dated 16/2/2018. Further, there is no record of no objection certificate NOC from youth affairs in the source. Being the parent department, NOC is usually sought from only one letter from the then director, yes, addressed to the additional registered society seeking classification as to the objection being invited or not. The letter is dated 10 December 2009, way after registration was done. The next page, man. At this juncture, my lord, is directed by the Honorable Court to consider both the facts and present it before the court. The following is stated. This is very important. Hockey Manipur is the legal entity. As it is the amalgamated unit from both men and women as per the condition of IOA, though registration under was accorded for this amalgamated body in January 2010, having followed all the existing rules and procedure. However, Manipur Hockey has violated the norms of registration Section 5, Section 10, and Section 13 of Manipur Society Registration Act, and hence it is illegal. Matter ends there, my lord. Matter ends there in the sense that, my lord, this is the, if it is the letter, but this letter is pursuant to the interim order passed by the court. It is to be treated as an order. And then it is very clear that the Manipur Hockey is the legal body and Hockey Manipur is the amalgamated unified body of the two associations. That this has not been challenged as yet. What their answer is that this letter was issued very biasly, very favorable, and then bias, and then, my lord, favoritism, nepotism is there, tainted with favoritism, nepotism is there in issuing this letter. That was the contention of the petitioner before the learned judge, and it has been reflected in the judgment. Now it is stand still. It's, my lord, Phil is still there. They can't claim that they are legal. This is maintenance there. They have not been challenged. And this is the fourth point, my lord. Now it has been reflected in para 42. It has been reproduced in the judgment. Para 42. Para 42, my lord. And then para 54 is also very important. Para 42, my lord, just highlight it. Para 40. And then next I'll come to para 54. What their strong argument is that, my lord, as I stated earlier, they have produced international player, they have produced national player, they have produced that player. They are the real association. But the question is not that. We have also produced several international player, national player, gold. That is not a question to be considered before the learned single judge. The learned single just come into conclusion that it's pure question of law. So therefore, the para 54 talks about, my lord, of the learned single judge order, my lord. Let me read out with the permission of your lordship. At this juncture, my lord, I'm reading para 54. At this juncture, learned counsel for Manipur Hockey submitted that Manipur Hockey is the only bona fide affiliated and recognized by the Hockey India and the MOA for the sports hockey in the state of Manipur. According to learned senior counsel for Manipur Hockey is the body which has conducted tournament at different level in the state of Manipur. And on the other hand, Hockey Manipur has not undertaken not a single activities worth its name. And in other words, it exists only in paper. It has been clearly recorded by the learned judge. And then para 55, countering the said submission. This is the submission, and I'm also countering to that submission, stating that that's been recorded by the learned judge. Countering the said submission, the learned senior counsel for Hockey Manipur submitted that many members of the Hockey Manipur have been participating in various national and international level hockey matches. Nothing has been produced by Manipur Hockey to show the Hockey Manipur is existing in paper only, and no activities are undertaken by them. Just mere allegation has to be proved. That has not been proved. And then Millard 55, para 55. And then 56, your lords. It is true that Manipur Hockey has conducted many tournaments. That learned single judge also admitted that Manipur Hockey has conducted many tournaments at different levels in the state, and equally, Hockey Manipur has also participated in various national and international level hockey matches. That is not the issue to be decided. Recognition of the MOA, non-recognition of the MOA, or Indian Olympic Association, this is not the issue to be considered before the learned judge. The issue is that relevant to Section 7, Section 10, Section 11, and Section 12, and pertaining rules. And finding came and passed over. Now, 56. Then para 57, let me read. It is clear from the material produced at the time of the formation of the Manipur Hockey under Section 7(1) of the Manipur Society Registration Act 1989. The two societies, namely Manipur Hockey Association and Manipur Women Hockey Association, were in existence, and thus there is gross violation of the Section 10 of the Act of 1989 in the registration of Manipur Hockey, finding that 11 of the Act provide change of name. The Secretary Corporation was rightly directed the Manipur Hockey to change its name, because they are very fortunate. Instead of quashing this certificate, the learned judge resorting the Section 11, correct? Section 11, directing to the authority to change the name in memorandum. They are very fortunate because they blatantly violated the Section 10 according to the factual matrix of the case. He has rightly directed Manipur Hockey to change its name and alter its memorandum within 3 months. The aforesaid view and conclusion arrived at by the Secretary Corporation is in the interest of both hockey, Manipur Hockey. This court is of the view that such a conclusion arrived at by the Secretary Corporation is based on the depth examination and consideration of the substantive point put forth by both the parties, and also taking into consideration that both Hockey Manipur and Manipur Hockey have committed and produced many of the players. And 58, Milo, let me refer to 58. For the foregoing discussion, this court is of the view that the Imperial Order 21/20 has been issued by the Secretary Corporation pursuant to a series of orders passed by this court and the letter correspondence of the respondent author. Therefore, there's no ground to interfere with the Imperial Order. This is the finding. Para number. And then, Milord, let me refer to para 59. Milord, in view of the categorical finding right, this is the finding of the learned judge. By the Secretary Corporation and the issuance of the Imperial Order, this court finds that there is no infirmity in the Imperial Order so-and-so. Ground taken by challenge, the Imperial Order dated so-and-so. Therefore, the Imperial Order dated needs to be implemented as directed by Secretary in the Imperial Order so-and-so implemented. So really on the prejudice would be caused to the Manipur Hockey. On the other hand, if it is not changed, the concept of the amalgamation of two old societies is meaningless. Now, the first point raised by the appellant is that there is a irregularity to amalgamation. That amalgamation statement and record was not brought before the Honorable Learned Single Judge. And this order was disposed of in 2022. Now they are trying to brought those papers which were received in 2023. And then Honorable Chief Justice and your Lordship passed order saying that allowing to file the additional affidavit. That we all know it, if there be any facts and materials wanted to file before the division bench. In that case, there must be the misapplication, praying for leave to file, but that has not been done. Therefore, this, no, my lord, I'm not saying that this is, my lord, we have a lot of things to be controlled in this subsequent record, but this cannot be considered by the division bench. It's out of jurisdiction. Because honorable division bench can look into only correctness and legality, the veracity of the judgment passed by the honorable court, learned judge. This cannot be considered. So the first point, that is amalgamation procedure illegal. Now this amalgamation proceeding has been challenged before the single judge at Imphal. Now I brought the report. Repetition. Repetition. I give them all. I give them all. I give them. And order also I brought that order. Order to go. Can I take? Oh yes. Now, Your Lordship, now let me refer to the prayer portion before the learned single judge, because this is absolutely barred by res judicata, my lord. Absolutely barred, because this is a frivolous writ petition. This cannot be done.
It's pending there.
Pending there only. What they are praying is that, my lord. What they are praying is that, my lord. Prayer page 24. Prayer page 24. Prayer page 24. Lord, to issue a writ in to initiate to respond in this behalf. The small compilation is, my lord, I filed a miscellaneous objection saying that it is not the proper writ petition to be filed. It should be rejected at limine. I'm praying that. Lord, to make the rule absolute, if and when the respondent failed to so cause, to issue a writ in the nature of certiorari for quashing the registration bearing number so-and-so 21/1/2010, which has already been dismissed by the learned single judge. This 21/1/2010, because this prayer, my lord, this is the certificate issued in favor of the Manipur hockey. And then in the representation, what they are praying is that to cancellation this certificate. This was dismissed by the learned single judge. Now they are praying before this court. Lordship God. Now again, my lord. Next page, page 25. Manipur granting registration to Hockey Manipur at NHL A13. My lord, let me refer to NHL A13. This is the certificate issued in favor of me. Unified body of the two association, Manipur Hockey Association, Women Hockey Association, namely Hockey Manipur. And the representation, they are praying for consideration in the writ petition disposed before the Honorable Justice Muralidhar, and that was dismissed. Representation praying inter alia to cancel the registration certificate, that was dismissed. Now, whether they can claim the dismissal, praying prayer for dismissal of the another writ petition, it definitely comes to res judicata, constructive res judicata, section 11. Section 11. And then thereafter, my lord, next prayer number D, to issue a further writ in the nature of mandamus directing the respondent number 1 and 2 to consider dispose of the represented 29/12/2017. Same has also been dismissed by the learned judge, Honorable Justice Muralidhar, in his judgment, my lord. If your lordship look at the prayer portion of the writ petition, 916. Then your lordship may find 916, my lord. Piro. Page number 66, my lord. Prayer number D. Page 66. 66 of the writ appeal. Hmm. 66 million. To issue a further writ in the nature of mandamus directing the respondent number 1 and 2 to consider and dispose of the representation dated 29/12/2017. It has been prayed before the single judge, before the learned judge, was Honorable Murali, and this prayer was dismissed. Consideration of the representation was also dismissed. What the consideration, what the prayer of the representation is to cancel the certificate of the Hoki Manipu. And the notice issued to the Manipur Hoki to change the name and the memorandum by invoking Section 11 of the Manipur Society Registration Act and rules from therein. And then this prayer has been dismissed by the learned judge. Now they have been prayed before the learned judge. And then, my lord, the cancellation or dismissal of the representation 29/12/2017. Now they have filed a reminder application, my lord. Reminder application pursuant to this rejected representation 29/12/2017, my lord. That your lordship may kindly see the reminder application, my lord. Page 200 of the writ petition pending before the learned judge. No, my lord, this is something which, my lord, the learned senior counsel, with due respect, because this writ petition can be remitted back to the, learned single judge judgment may be set aside and directing to hear the matter before the learned judge. There was the contention before the learned, before your lordship, last occasion, whether it is permissible under the law. Things cannot be touched directly. He's trying to touch indirectly in such a manner. Now, this is the first point. This cannot be prayed because this is strictly barred by res judicata. And then your lordship must be knowing better than me that your lordship convenient, let me report. This is this is explanation. No court shall try any suit or issue in which the matter directly or substantially in issue has been directly and substantially in issue in the former suit between the same parties. These are the same parties and the same prayer. And modifying and filing the, this thing, my lord, representation, reminder representation. That reminder representation is the dismissal representation by the learned judge, whether it is permissible under the law. This is the first point. This cannot be. In this regard, my lord, lordship, last occasion, my lord, it was listed Honorable Justice Gourmet. Order, the lordship must be having that. What I submit before this court, before the learned judge is that Mr. S. Bishor's learned senior counsel, assisted by Mr. A.K. Sundar M.B. learned counsel appearing for the respondent in the miscellaneous application requested to file objection to the miscellaneous application for maintainability of the main writ petition, which is objected by so-and-so, Mr. So-and-so. It was listed on 8/3/2024. Whether this writ petition can be connected the present writ appeal pending before this court. What is this, my lord? What is the prayer? It's a hopeless prayer to my understanding. I'm sorry. Hopeless prayer. And this writ petition was filed when? If they wanted to challenge the certificate, this has been filed after 13 years of delay. If there be 13 years of delay in filing the writ appeal, then there must be some statement relating to the delay. There's no explanation at all. 13 years is not easy. There's no explanation at all, my lord. And then third point is that, my lord, there is a provision of limitation for filing. Statutory appeal is there. Then, my lord, Section 12, Clause 3, my lord.
Oh.
Section 12, Clause 3, my lord. Nothing you can do to you. Certificate. My lord, my certificate was issued on 21st January 2010. Under Section 12 of the Society Registration Act, my lord. Now, Right. Milord, Section 30, Milord. Limitation. An appeal under this act may be filed within 30 days of the date of the objection or other appeal against. The provision of the Section 5 and 12 of the Limitation Act 1963 shall apply to any appeal under this act. This is Section 30. Rules to. And then there are two provisions of the appeal. That is Section 12.3. 12.3. In respect of the certificate issued in respect of the Hockey Manipur, my lord, registration was done in Section 12, amalgamation. So therefore, Section 12.3, an appeal shall lie to the state government against any order of the state government on such appeal shall be filed. They cannot come directly before the High Court. They should have been exhausted by statutory remit. After 13 years, if it is allowed, even one can come even 30 years, 40 years, if it is allowed. The purpose of having the Limitation Act enshrined under the Act itself doesn't have any meaning. Now again, rule, my lord. Let me refer to the rule. Rule to Yoguni. So wrong. Huh? Huh? My lord, rule 37. Yes, my lord. The lordship must be having rule 37. Rule 37. An appeal which is applicable under Section 7.3, 9.3, and 12.3. Now the 12.3 is relevant because the amalgamation proceedings is under Section 12. Shall be made in the form of the memorandum and shall be accompanied by the original or certified copy of the order appeal against and a challan of the payment of the rupees 500 so and so. Every appeal shall. These are the procedure. But that has not been done because they wanted to challenge the certificate issued on 21st January 2010. Then in that case, it was issued on Section 12. Then Section 12's appeal provision is there. Statutory appeal provision is there. They have not been resorting there. After that, after 13 years, they filed the writ petition challenging this. Ignoring and overlooking all the statutory provision, my lord, it is not permissible. Therefore, I filed a misapplication. Now, with due respect, this senior counsel submitted that there is a pending case. So it is closely related. So therefore, this judgment should be set aside in sending this reconsider. What is this, my lord? Without any substantial and justifiable reason. This is hopeless petition. It's running here and there, my lord. I wanted to argue the misapplication, but he wanted to file. What to be filed, I don't know. What I am submitting before this court is absolutely, question of law. So therefore, my lord, and then, my lord, I filed the counter affidavit. And that counter affidavit, I have stated very clearly that has not been controverted. Now, in this regard, the factual metrics of the case, my lord, let me refer, because if your lordship assuming not admitting, if this document which subsequently placed before your lordship, it is not the record of the division bench, because they have not even filed a miscellaneous application praying for allowing to file the additional affidavit. Therefore, your lordship cannot take the cognizance of the additional affidavit as because this is 2023, records. And the learned single judge disposed of the case in 2022. And then this record which produced before lordship would have been placed before the learned single judge, Honorable Justice Muralidhar. Then in that case, the judgment would have been otherwise. So in this regard, my lord, the Supreme Court says that, my lord, the judgment passed by the Supreme Court, there are number. My lord, 2002 Supreme Court cases 734, my lord. Para 10. Para 10, my lord. As your lordship knows, my lord, in the judgment, my lord, there are three elements: ratio and obiter dicta and statistics, my lord. And para 10, my lord. We may refer to the next ground on which the appeal has to be allowed. It is settled position of law that an appeal, the parties cannot urge new facts. From the pleadings of the respondent before the State Commission, it is found that the respondent pleaded that the property damage was not covered under the insurance policy. This plea was given a go by before National Commission. A new plea was taken up in the ground of appeal that the terms and conditions of the insurance policy were violated by the appellant by issuing use so national so. It goes to say ratio is that, my lord, in the appeal, the party cannot urge new facts. Otherwise, the learned single judge would have been passed otherwise. If a lordship say, for example, if the lordship, I do not submit a very important facts while arguing the matter, and the matter available before a lordship in the lordship pass order, and then challenging the learned single judge, then producing the new facts and saying that no, it was not considered, whether it is permissible under the law. Therefore, the Supreme Court says that no, new plea cannot be urged before the division bench, which you have not been placed before the learned single judge. Now, another judgment, my lord. AR 1953, my lord, plea on the PO. Chiller. Para 22, my lord, right side, middle part. Para 22, right side, middle part. Second para, right side, my lord. Para 22, right side, second para, my lord. It is also held that the plaintiff claim in respect of this item so-and-so was within limitation. We are unable to uphold the view taken by the High Court on this point. It is well settled that the decision of the case cannot be based on grounds outside the pleadings of the parties. Lordship got it. This is, my lord, this is a settled principle of law. Now, another judgment in respect of the bringing the new plea before the division bench. Now, my lord, I'm not saying that this additional affidavit can be taken cognizance by a lordship, because there is a fundamental error of the procedure for filing the additional affidavit. If your lordship, Honorable Chief Justice, was allowed to file the additional affidavit, but what is to be followed, they have not been done. Therefore, your lordship, I'm submitting my respectful submission before lordship is that this additional affidavit placed before the court and arguing on that basis can be considered. That is my submission for lordship consideration. Now, another judgment, my lord. 1997 Supreme Court. Para 6, my lord. Para 6, your lord. The question which falls for consideration is whether the respondent in their written statement have raised the necessary pleading that the license was irrevocable as contemplated by Section 60B of the Act, and if so, if there is any evidence on record to support that plea, it is well settled that in the absence of the pleading evidence, if any produced by the party cannot be considered, it is also equally settled that no party should be permitted to travel beyond the pleadings, and that all necessary and materials facts should be pleaded by the party in support of the case set up by it. The object and purpose of pleading is to enable the adversary party to know the case it has to meet. in order to have a fair trial, it is imperative that the parties should state the essential material fact so that other party may not be taken by surprise. The pleadings, however, should receive a liberal construction. No pedantic approach should be adopted to defeat justice on higher pleading technicalities. Sometimes pleading are expressed in words which may not expressly make out a case in accordance with strict interpretation of law. In such a case, it is the duty of the court to ascertain the substance of the pleadings, to place undue emphasis on form instead of substance of the pleadings should be considered. Whenever the question about lack of pleading is raised, the inquiry should not be so much about the form of the pleading. Instead, the court must find out whether the substance and party knew so and so, so and so, once the found so and so, so and so, so and so, then in that event, it would not be open to party to raise the question of absence of pleadings in appeal. Now, this is in regard of the known pleadings and non-bringing the material, documents which may be important for the appellant side before the learned judge. But the fact remains is that 22, the case was dismissed, and 23, through RTI, there must be something that has to be answered by the government. Government is there. Whether their, papers are correct or correctness and legality. Now that cannot be brought before the division bench, because had it been placed before the division, learned single just order would have been otherwise. Now go back to the appeal, my lord. Go back to the appeal, my lord. Grounds formulated in filing the writ appeal, which has never been stated in the writ petition. What is this, my lord? Grounds. How many grounds? 22 grounds, which is based on amalgamation. Irregular amalgamation, illegality, correctness of the amalgamation. Grounds which you also may kindly see. There are 22 grounds, I suppose, that start from page number 26, my lord. Now they have raised new grounds, whether it is permissible under the law. 7.2. Internet page 27. For that, the learned single judge failed to appreciate that as per the section 12 of the Manipur Society Resolution 1999, whenever two or more society or amalgamate, the governing body shall submit a joint proposal in writing to the registrar for its prior approval thereto. It is specifically respectfully submitted that the so-called proposal by the said two association was submitted to the Honorable Minister Corporation so and so, so and so, so and so, so and so. Said proposal never submitted to. Whether this pleading was placed before the learned judge, whether they can be brought, this one of the ground. This is my great question. If this question have been raised before the learned judge, my lord, I do not find any pleadings, any sort of assertion, my lord. If your lordship may find, then this read appeal may be allowed. Not nowhere in the pleadings. Why they are forming this ground? 22 grounds. And if your lordship look the contention of the petition before the learned judge, contention and the grounds are quite different. Whether it is permissible under the law, your lordship. Contention, what their contention, if your lordship look at the contention of the writ petitioner appellant before the learned judge, there are 6 contention as stated by them. And now there are 22 grounds which never been stated in the learned single judge pleadings and the writ petition. What is this, my lord? I'm challenging that this judgment passed by Honorable Justice Moraliders is whimsical, as illegal, and arbitrary, my lord. And learned single judge rightly come into conclusion that section 10, and stating all the facts placed before him. What is wrong with the order? And they never submitted before the court. Then your lordship asks, when your lordship asks, what is wrong with the orders? They never submitted that. They submitted that amalgamation proceeding was incorrect. Number 1. Amalgamation proceeding was incorrect. And one writ petition was pending before the learned judge. Therefore, this appeal should be allowed in quashing the, setting aside the learned single judge, send down to the learned single judge. What is this, my lord? If your lordship look at the contention of the appellant stated in para 312, your lordship, 31236, and then grounds taken by them, my lord, 712, your lordship. 722. These are all where they have brought this ground, where they have not been written in the writ petition, whether it can be permissible under the law. Otherwise, if it is allowed, my lord, there may not be any ending point of the litigation. There is no limitation of filing the writ appeal, and one can brought another factual background, one can brought another, because law in respect, as your lordship knows better, law we can argue like anything, but then in respect of the materials and facts. So this is absolutely, this appeal should be dismissed at limine, even without going into the merit of the case. What is this, man? It is purely question of law. And then representing the international this and that has been answered by the learned single judge. And then amalgamation proceeding that has not been stated in the learned single judge. What is this? And then pending case before the learned single judge before the, this is absolutely, my lord, obvious petition. They have not even filed this. Okay, they have a right to challenge the certificate issued in favor of the Hockey Manipur issued in 2010. But they have to apply first statutory provision in respect of the appeals. They have not done it after 13 years. They can't do that.
Chandra, after 5 minutes.
Deeply obliged. And there's no wrong with the outcome. And then the prayer is only 2 prayers. And now they are saying before the division bench is that amalgamation proceeding is incorrect. It has not been done. That has been brought in 2023, yet to be brought. And that cannot be brought out. Because the very fact is that the very document which alleged to be the process is amalgamation process is wrong. Then in that case, and then if that be the place before a single judge, then we have ample opportunity to object it. That has not been done. And then 2 prayer has been specifically made. And they cannot claim for amalgamation proceeding is incorrect. No. And then on the basis of the protection of producing the international player this and that, and the recognition the MO this and that has been answered precisely by the learned judge in the paragraph. And the whole argument goes there. Now, therefore, in this regard, the one judgment, my lord. One judgment. Prayer. Yeah, yes, my lord. There are 15, my lord. It's very short. It's relating to the family matter. But however, my lord, there are 15 middle part. It is settled law that para 15, coming to the address of second issue, while this court is not apathetic to the predicament of the respondent grandparent, it is a fact that absolutely no relief was ever sought by them for the change of surname of the child, so that to that of first husband. So the respondent, it is settled law that relief not found on pleading should not be granted. Now, are they praying for this thing, my lord? Cancellation of the certificate on the basis of the irregular or illegal, alleged illegal amalgamation? Nothing is there. Therefore, whole submission before your lordship by my good friend is illegal process for amalgamation, and they produce the international player and national player, state player, and their association recognized by MOA and the Indian Olympic Association. But that has been answered precisely by the learned. So in that regard, there's no doubt about it, undoubtedly. Now, my lord, in this regard, my lord, I have filed a precise counter PDB, and government also filed a precise counter PDB that has not been controverted by them. In this regard, my lord, let me report to the judge. As your lordship knows, the Nasim Bhanu case is a well-known case, my lord. तेरा क्या नाम? Para 9, my lord. The aforesaid reply would show that on behalf of respondent number 124, it was not disputed that 40% posts which have to be filled up by Para 9, my lord. Promotion had not been filled up, and the denial of promotion to the appellant was justified on the sole ground that she was not qualified to be promoted to LT grade. This shows that in the pleading before the High Court, there was no contest on the question that the post of LT grade, which was sanctioned on August 29, 1977, was required to be filled up by promotion for the reason that 40% post had not been so filled. Even though there was no contest on this question, the High Court has gone into it and has held that the appellant has failed to establish her case that at the time of the appointment of respondent 6 by the recruitment, 40% of the total number of the posts in the college were not filled up by promotion as prescribed by Regulation 52A of the regulation, since no dispute was raised on behalf of the respondent number 124 in their reply to the averment made by the appellant in the writ petition, and 40% of a total number of the posts had not been filled up by promotion as much as the said averment had not been controverted. The High Court should not proceed on the basis that the said averment had been admitted by respondent. In this regard, my lord, I have controverted all the documents, all the statements supported by the document, and government more particularly is stating very precisely by shown by the well-being officers and the competent officer. They have not been controverted. So it amounts to admit, because why we have issued order thereby directing you to, by invoking section 11, to change the name in a memorandum. Why? Because there is identical and nearly resemblance. Your registration is illegal in the sense that there is already two association identical and nearly resemblance. Therefore, you have to change your name. That was the issue to be considered before the division bench, and it was the core issue considered before the learned single judge. So the facts stated by the government matter has not been controversial amount to it. This is my contention before lordship, and this is my argument for your lordship consideration. Now another judgment, my lord. Para 18, 2010, 10 SCC 408. Para 18, my lord. The Union of India has filed its counter affidavit. It has denied various assertions made by the appellant, but insofar as the aforesaid assertion of the appellant is concerned, it is not stated by them that they had arrayed the state of Assam as a party to the proceeding, nor do they assert that the learned counsel for the state was heard in the matter. In our view, the respondent must deal specifically with each allegation of facts of which it does not admit to be true. The allegation of the fact, if not denied, controverted in the counter affidavit, normally it shall be taken to be admitted by the respondent. And another similar judgment, Miller, as your lordship knows better, Miller, and then I just, Miller, apprise to your lordship for your lordship consideration, Miller. 2012, volume 7, SCC 389, Miller. Para 17. It is a settled principle of law of pleadings that an averment made by the appellant is expected to be specifically denied by the replying party. If there is no specific denial, then such averment is deemed to have been admitted by the respondent. So they cannot say that now this and that, Miller. They can't say that.
So no reply was filed.
No reply was filed. No reply in the sense that no rejoinder, my lord, of the counter affidavit filed by the government, my lord, to the writ petition filed by the appellant. Because that counter affidavit is very important. On the basis of that, the said to be impugn order was issued, and that has been challenged by the appellant. It needs to be controverted.
How about your counter?
My lord, my counter also, they did not file any rejoinder. I have filed counter affidavit filed by the appellant before the learned judge, that is the 9916. That has not been. So therefore, what is the wrong with the order? If your lordship asks to them, what is wrong with that, they explain me. It is pure question of law. They cannot raise voice saying that amalgamation proceeding is wrong. When the writ petition was pending before the court, there was no any argument. There was no any point regarding the amalgamation is wrong, this and that. Why they are claiming before the division bench, saying that amalgamation one proceeding is wrong, this and that. So many things are placed before the division bench. Whether the division bench, with due respect, has a jurisdiction to just decide that. To my understanding, this is my respectful submission for your lord's consideration. Now, these are the this thing, my lord. What is this? My lord, another judgment, my lord, 2011, volume 14, SEC 243, my lord, regarding the pleadings, my lord. There are 10. A perusal of the writ petition would prove and establish that the only prayer made in those writ petition was to grant relaxation to the criteria and standard of physical condition prescribed for the required to be fulfilled in the aforesaid writ petition. Neither the validity to Rule 167 with regard to physical condition were challenged, nor were such conditions prescribed in the advertisement challenge on the ground of its validity, contending inter alia that there is no nexus of the said condition with the object sought to be achieved. We find that the physical condition prescribed in the advertisement are in consonance with Rule 176 of the police rule, which are statutory rule. Nowhere in the pleadings it is stated that such conditions prescribed are illegal or invalid. The constitutional validity of the aforesaid rule was never challenged in any of the writ petition. The High Court, however, without there being any pleadings in that regard, went beyond the pleadings and held that such physical conditions laid down are bad and arbitrary is what was being prescribed had no nexus with the object sought to be achieved. Now, before the learned judge, my lord, the amalgamation proceedings irregular, it is not followed, the procedure has not been pleaded, has not been played, has not been prayed in the proceeding. How the learned single judge pass order? Now they are saying before the division bench saying that this has not been considered, this was done it, whether it is permissible under the law. That has not been pleaded anywhere, my lord. If you also look at the contention, 6 contention and 22 grounds, then you also may find these are all hopeless. I know. And paragraph 14 and 15, my lord, same judgment. The state of Maharashtra and the Jagwan Municipal Council, this court has observed that in absence of any challenge, the constitutional validity of the amendment cannot be gone into. 15, we may also appropriately refer to the decision of this court in so and so, wherein also it was contended before this court that the absence of any challenge to the relevant rule, it was for the High Court to depend from such recruitment rule. It also so and so. This is the further paragraph, my lord, the same judgment, my lord. So therefore, without pleading, without prayer, my lord, how they are saying that no, this pleadings was never been considered. If we have pleaded, that is otherwise. As your lordship can interfere right straight away. But here in this case, not that. Was there any pleading? Nothing. No record, nothing. They are before the saying that before the division saying that no, this irregularity cannot was there and therefore it should be sent down. Quashing the judgment and send down and decide before the learned. That was the argument, whether it's permissible under the law. What is the wrong with the order? If the learned single judge did not consider the material facts, that is otherwise. The learned single judge considered all the material placed before him and passed this order. So if your lordship look at the contention, 6 contention and 22 grounds, then your lordship may find these are what is this? And the prayer. And in the meantime, the interim order was passed by the Honorable Justice Nobin saying that inquiry should be done and the findings of the inquiry was there and the illegal and the legal. Manipur hockey is the illegal both and the hockey Manipur legal. That has not been challenged. And then, my lord, the additional affidavit that has been submitted by the appellant saying that we wanted to file the additional affidavit timely, give some time that the Honorable Chief Justice and your lordship was allowed And then they should have filed a misapplication, praying for allowing to file the additional affidavit that has not been, done. Whether this very additional affidavit can take the cognizance or can look by this honorable division bench? No. I may be wrong, but to my understanding, this procedure is absolutely wrong. So these are the all about of the case. Therefore, there's no illegality. There's no any infirmity of the learned single judge. Therefore, it should be, my lord, this writ appeal should have been dismissed. These are the background of the case. Now let me refer to another division bench order, another, my lord, case 28, my lord. This case, the case was filed by me for implementing the impugned order in the writ petition, your lordship, 916 of 2019. (28-23) of Guwahati. Here in this case, my lord, my colleague has submitted that in this appeal, they have filed the additional affidavit. Whether they have filed the miscellaneous application praying for allowing to file the additional affidavit, I don't think, my lord, I have not received as yet the misapplication praying for allowing to file the additional affidavit. But I don't know, my good friend argued on the basis of this additional affidavit, I don't know whether it is permissible under the law. If that be the case, one can submit this thing, one can submit these facts, and then your lordship cannot take cognizance of it? No. Now, my lord, let me refer to page.
What is readable 28?
28 is that, my lord, it is arising out of the WPC 724 of 2019, my lord. It is the composite judgment, my lord, of the two writ petitions. Now, therefore, my lord, page 28, if you also look at page 28, my lord, I would invite you, lord, of 28 of 2020. Writ appeal 28 of 23 of Guwahati and 97 of 22 of Manipur High Court. Now, prayer, my lord, I quickly go to prayer, my lord.
Page 28.
Page 28, start from page 28, and the prayer portion is page 47. Page 47, prayer portion. This is the writ petition filed by me. That is Manipur Hockey Manipur. Prayer, Roman number 3, prayer, my lord. To issue a writ in the nature of mandamus, certiorari, or any other appropriate direction, order directing respondent.
1 minute, something is wrong.
Yeah.
Page 48.
My lord, 47, prayer 40, page 40. My copy, my lord, which have been served by them, is page 47. Internal page 47.
Internal.
Oh, yes. And my writ petition start from page 28. You also got it.
28. No? Yes.
I also got it. Now, my lord, Roman 3, to issue a writ in the nature of mandamus, certiorari, or any other appropriate direction, order directing responding to implement and execute the order dated, order so 22nd January 2018. This is the very order, my lord, impugning by the appellant before the learned single judge. Lord, that is writ petition number?
Something is wrong here.
No. 964.
Page 47.
916. 916 of 2019. That's all. Does you got it? Prayer portion, my lord.
Okay.
Now the prayer. This is the case filed by me before the learned judge. Now my prayer is that the 22nd January should be implemented. The 20th January 2018, wherein, my lord, this very order has been challenged by filing the writ petition 916 of 2019 by my good friend before the court. And simultaneously I filed this writ petition for implementing this order, thereby directing to the Manipur Hockey to implement or to change the name and change the memorandum. Now, I'm praying here in this for implementing this order. Now, Roman 4, direction to also respond to consider and dispose of the, representation of 4/9 to 2019, that is page 97 to 101. Herein. Now, it has been allowed. It has been allowed, and their case 916 to 2019 has been dismissed. So, this is the herein in my lord. This is the case which I filed. Now, after filing this case, my lord, they have not even controverted. They have not filed counter affidavit here also. They have not filed any counter affidavit here. They have not filed any counter affidavit. And instead had filed a counter affidavit. And the inquiry report was there. And that inquiry report, my good friend has argued that on that inquiry report, that has to be answered by the government. There was 3 points which argued before this honorable court by Mr. Godfrey, my colleague. That is, procedure in regard of the amalgamation is derogatory to the established norms enshrined under the rules and act. Secondly, they have been recognized, the Manipur has been recognized by MOA and the Indian Olympic Association. Thirdly, they have produced international player this and that. That issue has been answered by the learned single judge precisely in judgment, saying that no, that is not the issue to be considered before me. Because you have not been raised any voice regarding the correctness and legality of the amalgamation. Never raised. And the factual background, the petitions also submitted, they have produced the international player, national player, state player. And the Hockey Manipur also saying that that has to be considered, that has not been considered because I am go to the strictly as per the law. And this judgment has been decided strictly as per the law. So therefore, your lordship may kindly ask to them, what is wrong with the judgment? They won't have any answer to that. Now, my lord, this page 114, this is the inquiry which my colleague has to answer. Now, here also, my lord, they have not even filed a counter PDB. They have admitted everything. And the government filed counter PDB. That has to be explained by them. Therefore, my lord, these are the writ appeal challenging the learned single judgment without any substantial basis and justifiable and conceivable reason. They have formulated the 22 grounds which has never been stated in the writ petition before the learned judge. And their contention stated that they have stated themselves saying that this is the contention before the learned single judge. While for formulation of the appeal, they have reproduced 22 grounds which never been placed before the learned single judge. So, this is the appeal filed by the appellant. It's absolutely, my lord, frivolous appeal. It cannot be, my lord, on this basis, the writ appeal should have been dismissed.
What is this report, inquiry report?
Report, my lord, this is the inquiry report. My lord, that your lordship may kindly see that this one Pradeep Kumar inspector regarding the Manipur Hockey and Hockey Manipur. Regarding the Manipur Hockey and Hockey Manipur. It doesn't say anything. It is something different, the issue which has been decided by the learned judge. Learned judge has decided only question of section 10 more particular. There is already two associations registered in 1976. And 2010 Manipur Hockey was registered. 2009. And 2010 Hockey Manipur were registered. So learned single judge says that no, 2009 you cannot register because section 10 is there. There's already existing two associations, identical and nearly resemblance. So therefore, this registration is incorrect. It is barred by section 10. Therefore, invoking section 11, the commissioner and registered issued notice saying that you change the name in the memorandum. Because registration day of the Hockey Manipur 2010, the two associations registration was cancelled. On that basis, the nursing will just pass over.
How long will take, Hemchandra?
My lord, I'm coming. I'll finish I won't, because it's very clear.
No, I'm not stopping you.
No, my lord, my lord, I know, I understand, my lord, I understand, my lord. To my understanding, and then I will try my level best to convince your lordship, and then I'll finish. No, this inquiry report should be answered by him. So therefore, ultimately, after taking into my the factual background and law laid down by the Supreme Court, my lord, this writ appeal is not maintained. And saying that one writ petition is pending. And only on that ground, this judgment passed by the learned single judge said could be set aside, and then matter should have been remitted to the learned single judge. Pending before the. What is this, my lord? As I stated earlier, what are the prayer in the writ petition pending before the court after 13 years? And that prayer has already been dismissed by the learned single judge. And after 13 years, no explanation. And third point is the red judicata. I am not required to explain to your lords. The lords better than me. So therefore, this writ appeal should have been dismissed at limine. Deeply obliged.
Keep it part only. How long you'll take, Athoba?
My lord, I will take almost around 1 hour, my. Between half an hour and 1 hour, because the facts also need to be convinced before the honorable court.
Kalita will take some time.
Yes, no, sir. We'll have to reply to both the councils.
My lord, if the
Then,
court, if the honorable court permits, then I will start and I will brief the matter, my lord, concisely, my lord.
See, we are having single bench also, so we are not sitting at 2.
My lord.
So practically half an hour is left.
Yeah.
So I think that within that half an hour, I don't think we can squeeze it.
No, I'll require at least an hour, Lord. I mean, I'll have to reply to both
No,
my
I thought,
learned
it-
friends.
About half an hour, 45 minutes.
Yes.
Then we'll keep it parted and fix it.
Right.
When is your Yaoshang holiday?
Yaoshang is last week, my lord,
Last week.
February, my.
February or March?
March last.
Then March also we have holidays. Huh? Hmm. Give a date, convenient.
Yeah.
Kalita, you are here, there's no issue.
Yes, Lord.
What's
Yes,
the
Lord.
product
Yes,
that-
yes, Lord.
My lord.
No, with the conveyance.
April the policy of
Yeah,
this
no
week.
problem.
My lord, if possible, 2nd April,
April.
yes, if it is long or will be in the 3rd of March, 3rd week.
Third week, we are not here. I mean,
My lord.
my brother is not here.
My lord.
April 2nd is fine. April 2nd is fine.
Second,
2nd of April is fine.
second,
Okay.
or 14, 14 March. 14 March, April. My lord.
2nd of
Second of-
April, Lord.
My lord's convenience also, my lord. My proposal will be, my lord, either
Yeah, here is
14
second
of March or 2nd of April, man.
14th, I have some problem. 2nd of April, we can do it.
April, we don't know, because Rooster is not there. Oh, we can fix it on the first week. If
First-
there's no bench, then we'll defer it.
1st of April, first week of April.
First week or second of April, any date.
2nd or 4th also, my lord.
4th will do.
My
no
lord's
problem.
convenience, my lord, honorable court's convenience.
Okay.
4th of April.
Heard Mr. A. Kalita, Learned Counsel for the appellants. Also heard Mr. Athova, Learned Additional Governor Advocate for the state respondent. Mr. M. Chandra, Learned Senior Counsel, assisted by Mr. Jinu Rahman. And N. Anik also, N. Anik Singh for the respondent number 3. Heard in part, list for the hearing again on 2nd of 4th of March, April, isn't it?
4th of April. yes.
4th of April, 2020. Will be good.
Obliged, madam.
But very happy to argue with your lords because coming here, because it's very interesting. It's a great chance to have argue with your lords. The patient hearing this and this. Okay.
May I please, Your Honor?
That recapitulate, yeah, I forgot to put this. Yes, please.
May I please, Your Honor? Madam, I am praying for listing of a matter. It was last listed on in the month of September 2023.
Hmm.
The petition has been illegally terminated, madam.
Hmm.
May I pray the matter will be taken up on 7th or 11th of March,
7 will be some difficulty.
11th of March,
11, how about 13? 13?
13th. Debut.
May I please, your lordship? My lord, I beg to mention item number 5, my lord. It is a part of the series, my lord.
Hmm.
My lord, what has happened, my lord? This matter is something different, my lord, and therefore, my lord, may I pray that this matter may be segregated from the series, my lord. Otherwise, the petitioner will prejudice. This is a case of promotion, my lord. And the other matter relates to, my lord, termination or some other benefits they are claiming.
Okay.
My,
Are you sure?
yes, my lord.
On request made by Mr. A. Boyan, then it's counsel for the petitioner. Segregate this with the rest of the other, with the batch of other writ petitions. And list the matter on its own. On,
My lord, for second week of March, my lord.
okay, on 15th March.
My, obliged.
May I please, Your Lordship? Also, I beg to mention for listing my motion meet on Friday, madam.
Friday, what is the urgency?
Lordship, my graduate degree is ordered as cancelled. For that count, my rank may be demoted.
May I please, your lordship? I would like to mention item number 11 for adjournment for 1 week, your lordship.
You are for?
Petitioner on behalf of PJ Pukat.
On request made on behalf of PG Foucault, learning counsel for the petitioner. List of the 2 weeks.
Highly okay.
May I please, your lordship?
Hmm.
First, I beg to mention for listing of a matter, my lord, for admission, my lord, on 13th, my lord.
13. Okay.
Much obliged, man.
May I please, my lord, sir, I am praying for listing a matter for admission.
18th,
Oh, let me-
18th March.
Wait, Lordship. Lordship, I beg to mention item number 15, Lordship.
Hmm.
We have taken concern from the other side, Lordship. Lordship, matter may be adjourned today and fix the matter on Thursday, Lordship, 29 to 2024. Lordship.
Yeah, playing on behalf of?
Mr. Eka Purkasta, Lordship.
Okay, on request made on behalf of AK Progress, Leonard Counsel for the petition. List on 29th.
Yes, Lordship.
Item 1 to 4 of daily list, admission.
There was an adjournment request, isn't there? Huh? Okay.
Lordship, as per your lordship last court order, I was directed to bring in instructions regarding the publication of the list, Lordship. This is the instructions which I have received.
What was this?
I'll just tell your lordship what was the case about. It's regard about that there was an order passed by this court. We are all master role worker. Master role worker working in a Department of Water Resources. So there was somewhere we were master role worker, but there is a notification of 2010 OM. They said after 2000, if your lordship kindly see it and be clear, 3900 of 2017. Item number 2, my lord. Item number 2. Kindly see 264, page 264 of 3900 of 2017.
Which?
Page 264. 264. See this OM 30th of October 2001. Lordship got it? Government and examine the question of continuation of the master role worker work charge employees engaged after 1/4/1993 who have completed 5 years of continuous service pursuant to the order of the Honorable Guwahati High Court in WP number so and so. After a careful consideration on all the aspects, it has been decided that the master role worker work charge employees who were engaged after 1/4/1993 and completed 5 years of continuous service as on 24/1/2001 shall only continue in service in their respective capacity, subject to proper verification of their engagement by the respective appointment authority. So this is what, my lord, they have to verify. That whether this particular exception which is given to those master role worker who is before this court, whether this exception which was given, that verification work has to be done by the government. This is the OM says. Now, this was moved before this honorable court and there was an order passed at page 253. Kindly see 253, my.
253
253 is the order. Order of this court,
of this writ.
of this writ petition. Kindly see the second. Having heard the learned counsel, this court has passed an order on 8/4/2010, which is inter alia. Considering the matter in his entered.
Para?
No, it's a one-page order.
Okay.
One-page order.
Hmm.
One-page order. Having heard the learned counsel party, this court has passed an order on 8/4/2010, which reads inter alia thus. Considering the matter in its entirety and in the interest of justice, it is hereby made clear that unless otherwise directed by this court, there shall be no bar on the part of the state respondent to engage the present petitioner in the field work of the department along with similarly situated other person if such an engagement is legally made. It is further clarified that the engagement as has been permitted by this court by its order dated 8/4/2010 is the first part, the above part of the paragraph which I read, shall not be any manner which may come in conflict with the observation made and direction given by a full bench of this court in Jitendranath Kalita versus State of Assam report in 2006 2 GLT 654. As regards the claim of the petitioner that they have not been paid the dues for the period for which they had worked, it needs to be pointed out that the contention of the petitioner that they have worked is disputed by respondent. For such a disputed question of fact, a proceeding of the present nature under Article 226 of so and so is not the appropriate proceeding, inasmuch determination of such a question would require making of roving inquiry and adducing of evidence by the party concerned. In such circumstances, as far as the petitioner claim for non-payment of the dues are concerned, the petitioner shall have to take recourse to appropriate provision of law for remedy of the grievances. If any proceeding is instituted by the petitioner claiming payment of the alleged dues, the observation made on a finding recorded by the respondent in the enquiry report on 19/11/2008, so and so shall not be binding on the petitioner, though the same may be relevant for the respondent in order to sustain their findings in the matter. So after this order was passed, my lord, at the government level, at page 255, this is after the order was passed, 12 October 2010, which was written by Chief Engineer Water Resources to the Secretary Government of Assam. If your lordship kindly see the second paragraph of 255. Again, as per the office memorandum circular issued by various departments as effort by the government, it is observed that most of this put emphasis on the ban on engagement of master-role worker after 1/4/1993. However, as per OM dated 30/10/2001 and subsequently published so and so, is stated MR worker who engaged after 1/4/1993 and completed 5 years of continuous service as on 24/1/2001 shall only continue in service in their respective capacity, subject to proper verification of the engagement by the respective authorities. Now, I'll put a pause for a moment. That day, your lordship has put a query about the judgment of Upendas. My lord, it is a fact that after 1/4/1993, you cannot make this service regularized by the government. Prior to 1/4/1993, certain claims were made by those employees prior to 1/4. And they said that our services, we have put so much long years of service. So our services should be regularized. It was placed in a cabinet, policy was taken, and their services regularized. Similar situation after 1/4/1993, they came to a court. And it went up to a division bench, which will also. They said the court said we cannot give a direction regulation of the service. So now, this 2000, that was a notification of 1990. That notification was earlier of 1995, 24/1995 in their judgment, where they relied on notification. Subsequent to that, this notification was issued, saying that no, what we'll do, after also it can be done, but that gap period of who have after 1/4/1993, but continuous for 5 years, that is till 2001, they shall continue only for the purpose of engagement as a service, not for regulation of service. Today, I have not come for regulation of a service. We have come engagement. If this situation, if it is vacant, now the problem started here. They have done some homework by the department because there was an order passed by the court. How they will verify? There are about 4,000 employees who have been who work with the water resources department. So that exercise has to be carried out by the department itself. So to see whether they fall within that category or not. 5 years complete, or they have completed 5 years or not, from the period that after 1/4/1993 till 2001, where 5 years continuous in service. That homework has to be done by them. Now, tomorrow, if they does the homework and intimate us that no, these are the employees who have not completed the 5 years, automatically we don't have any grievance. But that exercise has to be done by them. Whether that exercise has been done, these are the letters which exercise the government themselves is saying the exercise has to be made. Kindly further see 255, second paragraph, once more, my lord. Again, as per the office memorandum circular issued by various departments, as referred to by the government, it is observed most of this put emphasis on ban on engagement of MR worker after 1/4/1993. However, as per OM dated 30/10/2001 and subsequently published, it is stated MR worker who is engaged after 1/4/1993 and completed 5 years of continuous service as on 24/1/2001 shall only continue in service in their respective capacities, subject to proper verification of the engagement. This is the exception which was given. My services are absolutely, the division is right. This is the exception which was given. Now kindly see further. Now, so far as, now kindly turn to 256. In addition to the above, last paragraph, views of this honorable verdict on different government office memorandum circular positional department of the matter is already stated in his counter affidavit file. Further, an inquiry committee was constituted. Kindly note down. Further, an inquiry committee was constituted to make a detailed inquiry on the matter. Accordingly, the committee inquired the matter based on report and hearing on the present concerning and submit a report. Copy of the report is enclosed here for. Now we don't have a copy of the report. We along with the report, somehow we could get those particular employees who have been working in that department on the basis of the circular for a period of 5 years continuous. Kindly see for a moment this additional affidavit, my lord. There is an additional affidavit which we have filed. Additional affidavit, kindly see, my lord. 379. One additional affidavit which is filed. Lots you got it. See that 379. Along with the report, this was there. Statement in respect, 379. Annexure A. Statement in respect of work charge, master role workers engaged after 1/4/1993 and completed 5 years of continuous service as on 24/1/2001 under different division, which is prepared by Chief Engineer Guwahati. So this is what they prepared. So here the petitioners, kindly see one, Rafiqul Hussain is a petitioner before your Lord. There are few, not only this list, there are other lists also. So all these lists they have prepared. They have to find out whether this they have, as per OM, they have completed this 5 years or not. Today they may say, today they may come and before they say that there is no question, there is no post, there is no post. We absolutely, but please let us know whenever there are certain posts, they only have to engage us, not others. This is why we are before this honorable court. What exercise they have made? No exercise has been made. Now, if your lordship kindly see at page 215 again to the writ petition, again to the writ petition, 259. See, kindly see 259 of the writ petition. That is 28/4/2011. This is by Chief Engineer addressing the Secretary, 259. See, my lord, the last paragraph. On the other hand, there is a shortage of field staff in a department. So, in view of the Honorable Court's order dated 5/4/2000, that's what I referred, my lord. And towards implementation of the same, vacancy position of field staff are obtained from the respective division officers where the executive engineer respondent in WPC number so and so. However, to fill up such post, prior approval sanction from the finance SU department is mandatory. In view of this, the vacancy position as received from different division was forwarded to your honor and so dated so and so obtaining necessary sanction from finance department. So the process of filling up the vacancy may be initiated legally and future problem in the instant case may be averted. After obtaining sanction from the finance department and prior to selection, petitioner would be informed through so and so to submit their candidate if they like. Where is that? They have not done. They should inform us where that homework is done. So my simple prayer before Lordship is not that I am saying that my service is regular. Let it be disposed of by giving a direction to the department itself that they will exercise this homework and they will inform us that whether we fall under that period of continuous 5 years or not. There are 4,000 employees, they have to work out and they will inform. This is what they said. And prior to selection, petitioner would be informed to so and so to submit again if they like. But that homework has to be done. As on that, they have not done the homework.
Otherwise, you're all out of service.
Oh, yes, of course.
Present-
Throughout, yes, absolutely, my lord. Only what we are praying before this honorable court that they should do that homework, my lord, and inform to us whether we are covered by that OM or not. Whether that exception was given to OM of 2001. I don't know how many lists are there. This is one of the lists. There may be 100 of lists. We don't know. They have to prepare that. My lord, I don't understand what difficulty will be to the government, my lord, in preparing that list. And there is already an order. That's all those my letters your lordship has seen, those letters. I don't know what instruction my learned friend has placed before the court. There's some instruction he has placed.
What is this thus?
Lordship, as per your lordship query, the last occasion, that is page 379, which my learned senior had shown before.
the
the
additional
lordship, regarding the, in the additional affidavit, regarding the publication of the list, as per the department contention, the list was never published by the department. It's been reflected there only. May I read, lordship? With reference to the subject cited above, I have the honor to inform you that no such type of list as mentioned in your email dated so and so in context of WPC number so and so has been issued by this department or from government counterpart. No such list. And moreover, lordship, if your lordship turns to page 435. This is the continuation of the list from page 379. Only the names were there. No signature of any issuing authority. Who had issued this? Nothing is there, Lordship. Lordship. This is, moreover, Lordship, I would like to point out one thing, Lordship. In the additional affidavit, which my learned senior had filed, they have stated the age of Mr. Raju Ahmed, who had sworn this affidavit, as 33 years. Mr. Ahmed had sworn this affidavit on August 2023. His age is stated to be 33 years.
Where?
Lordship, page 370, additional affidavit. Page 370, I see so-and-so, aged about 33 years.
No, additional affidavit is filed by one Baharul Islam.
No, Raju Ahmed, Lordship.
Is it about 41 years? Baharul Islam.
Lordship, I have been got this copy, Lordship.
I don't know. What's mine is Baharul Islam.
Here also it's
Baharul
Baharul.
Islam.
Here's the Lordship, page
My
370.
lord, I'll just point out one thing before Lordship. This list, why they are shying away of preparing that list, my lord?
That's all.
That's all. Let's say that this list
Why
is not
not,
before.
why not you take steps? in
Yes,
terms
to
of the
prepare. Why
origin?
they are finding it difficult? Some agenda is there. They are not trying to prepare it.
In our,
Why? Forget about all this list for a moment. We are saying, please look into it. I am not asking before you can regularize my service. Only look this list. There are few orders. There are some government, your lordship has seen correspondence of the government. The government say, yes, some exercise has to be made. Why it doesn't do the exercise, my lord? Forget for a moment of the list. All these petitioner before your lordships, before the court, they will do the exercise, which is before this honorable court. Let them do the exercise, inform us. One page, my lord, with great respect, and say one page order only. That this can be disposed of with a direction to the department itself to see whether under the OM, all these petitioners, whether they fall under this OM, which continues of service of 5 years from 1/4/1993, which exception is given. Let a direction be given to the government to do this exercise. Within a period of 3 months, 4 months, let them do exercise, my lord. Forget for a moment about that list. Why not?
Lordship,
The
this is
exercise.
affidavit which I have received, Lordship. Here it's Raju Ahmed is shown. I don't know how it's been changed. I don't know. I'm not blaming any.
My lord, all this will be decided by government, my lord, whether
And
what
moreover,
is
Lordship,
That's a different
that's a
thing.
yes. Let's forget about that list first for a moment, my lord.
in our affidavit in opposition, which we have filed, Lordship, on 2017, Lordship, affidavit in opposition filed on behalf of respondent number 1, Lordship. We have categorically stated in paragraph 4, Lordship. Paragraph 4 of our affidavit. It is specifically stated that none of the petitioners were ever engaged as masteral workers, work charges, stroke employees under any divisions of the Water Resource Department. It has been categorically stated that they were not being ever engaged as masteral nor any work charge. None of the petitioners.
So that's why before you do anything, what this court is trying to say is that in terms of the OM, you take some steps,
Yes.
take some steps within a period of say about 6 months.
Lordship,
Yeah.
they were
And then thereafter you inform the petitioners whether the name are there in the list. That's
They-
all.
The matter.
they were never engaged by this department.
So
Lordship.
that we have considered that. But
Lordship.
how do you know that they have never been engaged? Have you taken the exercise in terms of the OM?
It might be, it must be, Lordship. Otherwise, it will not be possible to write in this way, Lordship. It is on record, Lordship. It is.
Why you have not been informed to us? It was duty as per the order that to inform to the Assam Rajyik Karmasai Parishad.
In
They did not inform
2008, Lordship, after that, in 2008, the Water Resource Department formed a committee to examine the records of the master roll workers engaged after 1/4/1993 and completed 5 years of service up to 2001 under different divisions of the Water Resource Department and found that only 3 such workers are working in Hydraulic Research Division after releasing 8 persons from such engagement. there is no record of even drawing any payment by the petitioners for their master roll stroke workshop period is available in this department. As admitted by the petitioners that they have moved to the Honorable Guwahati High Court under the banner of Assam Rajyik Karmachari Parishad, termed as master roll worker on honorary basis. However, Water Resource Department has never engaged anybody on even honorary basis, Lordship. Next para, Lordship. Paragraph 5, Lordship, that as regards to the statement made in paragraph so-and-so, it is further stated that this Honorable Court in WPC so-and-so passed an order dated so-and-so where the Honorable High Court expressed that there shall be no part on the part of the state respondents to engage the petitioners in the field work of the department along with similarly situated other persons. If such engagement is legally made and also directed to the petitioners to claim for the payment of their alleged dues. However, no claim till date has been made as directed by this Honorable Court, which proves.
Yes.
Lost.
You have a look at this poem
Lordship.
in the meantime.
Lordship.
This petition by giving a direction to the government to do this exercise in a period of 6 months, your lordship has said, 5, 6, whatever is your lordship, it suits your lordship. That exercise has to be carried out. On one thing, this is most important, that at page 256, one second, I have shown my lord to your lordship at page 259. 250. 28/4/2011. I got it. My lord will kindly see. Yes, we have already read that 12 October 2010. That is page 255. Last part, kindly see, my lord. 12 October 2010. Kindly see the last part. This is Chief Engineer writing Water Resources to a Secretary, last part. Kindly see last. In addition, the above examined view of the Honorable verdict and different government office Memorandum circular, the position of department on the matter is already stated in the counter affidavit filed in this court. For the inquiry committee was considered to make a detailed inquiry in the matter. Accordingly, the committee inquired the matter based on report. Hearing on the present concerning executive engineer submitted a report. A copy of the report is enclosed herewith for review and further instruction order on this matter. So let them do the exercise. Why they are finding it difficult to do the exercise? We have ventilated our grievance. I am not saying that you regularize my service. Only inform us.
Whether your names are there.
Yes, of course, on the basis. And all the petitioners before this court. My learned friend has reading certain affidavit. Said, no, they have not worked. Fine, they have not worked. Intimate us on the basis of that list has been prepared. And whoever the petitioner before your lordships, ventilating the grievance, at least they should inform to us. No, you don't fall under that circular. You don't fall under that circular in pursuance of court's order. End of the matter, my lord.
Lordship, regarding the list has not been prepared by the.
No, that's, I'm not going into the.
Yes.
Lordship. Regarding the other factors, Lordship, regarding the age of the petitioners, that is also a question, means point to be decided, Lordship.
So
Because-
that's up to you.
No, because Lordship may kindly turn to page 370 of the additional affidavit, Lordship, that one page after.
No, we are ignoring that affidavit. Kindly see, my lord. Let us ignore it. That your lordship said. Forget about the affidavit, about the report also.
Lordship,
You do your exercise.
I am just
Yes.
pointing out one thing, Lordship, if my senior permits me, Lordship. This is the affidavit filed by Mr. Raju Ahmed. He has stated his age to be 33 years. One page later, Lordship, that is page 370, 2 pages are there of page 370. Page 372 pages are there.
370.
Yeah, 2 pages are there. I have seen from my senior affidavit, 2 pages. One is filed by Baharul Islam, just a page. Next page is Raju Ahmed affidavit.
Next page.
Next
Yes,
page,
two has filed affidavit.
marking as 370 also, both the pages.
No, 370 is Barul Islam.
Just Please turn the next page, Lordship. That
Next
is-
page.
Yeah.
Then,
There, Raju Ahmed affidavit is there.
no. The
It
next
is a-
page after this is para 3.
Actually mistake hoise etu because
Lordship,
370, 370 no.
378, Lordship, may kindly turn to page 378. Affidavit sworn by Mr. Raju Ahmed.
No, Barul Islam.
No, 370. আমার বাহারুল ইসলাম আছে
Here, Lordship, this is the affidavit which I have reading from my senior affidavit, Lordship. One page later, yes, it's true that page 370 affidavit is Baharul Islam. Next page is also page 370, which is by Raju Ahmed, Lordship.
No, there are not two page 70, only one
Well,
page 70.
Well, I'm sorry to disturb my learned friend. What he wants, well, he should just spell it out what he really wants from these two affidavit. He want to say that no, this is affidavit, some age is different.
Yes.
It is, this is what
Difference of
he,
age, Lordship.
how, what is,
That is the main.
today,
contention, Lordship.
today your lordship
Because-
is ignoring, my lord, let us ignore this. But why they are shying of the government being the government not to prepare this list? Why? That's I'm asking myself, my lord. Why they are shying off? We want a disposal from this court. I'm not asking the writ of mandama that my service to regularize. First opening of the case was that, my lord, my case is not for regulation. Is that they should do this homework. Why they are shying off to do this homework? Informing to us. One page, my lord. I'm sorry to say, my lord, one page order only dispose of with a direction which the petitioner before this honorable court, they will make this homework and inform to us whether we fall under OM or not. That's all, my lord.
Lordship, regarding the age of the petitioners, there is a question, Lordship, because they have stated in their affidavit, which I have got in my hand and also with my learned senior. The affidavit they have shown as showing the age as 33 years in the year 2023. And they have stated that in 2001, they have completed 5 years.
Please reject our case.
That affidavit is not before me.
No, what I'm saying, my lord, and now let
Then
us,
Lordship may take.
my lord, 1 second, my lord, let us say that this is the age factor is there. Then reject my case and inform to me. Reject our case and inform to me why they are not doing that.
Then Lordship may take WPC 5823 2021, Pranjal Kolita.
No, I don't understand why you're going into the age.
Because Lordship, age is also one of the factors.
So
Lordship.
that is why.
Age is also one of the factors. Lordship,
See, supposing according to you, if the age is this much today,
yes,
they could not have been appointed at that particular point of
yes,
time,
Lordship,
correct?
yes, Lordship.
So when you do the exercise, obviously their names will not be there.
Yeah.
Lordship,
Obviously, their names will not be there because they were underage for being appointed,
Lordship, we have,
for engagement.
Lordship,
So,
Lordship, we have already conducted an inquiry. As per the inquiry report, we have stated our affidavit that only 3 persons are there.
so
Except
where's
the-
the inquiry?
Lordship, we have stated in our affidavit, Lordship.
That we have read.
Yes, Lordship. Today I have, means, we have, in our report, we have stated, Lordship,
Where's your inquiry? You have not said that there was an inquiry.
then Lordship may give us some time, 1 week time, I will file it on record, Lordship. I will place it on record before your
It's a
Lordship.
simple matter, I don't know
That's,
why
I
you-
don't understand.
Lordship, where they have stated that only 3 persons are there in inquiry report. Now, how can the government will take the burden of, means the persons who were not being employed, Lordship? Even the list which they have prepared, means
That list I'm not taking into consideration
Lordship,
because
Lordship.
there's no signature, nothing.
nothing.
And according to you, there's no such list.
Yes, Lordship.
Anyway, I'm ignoring the additional affidavit.
Lordship.
I'm just coming to the office memorandum, that's all.
When they are not in the service, Lordship.
I don't understand. This is the first time, my lord, what I have seen through my practice for so many years, that simple we are asking for an exercise to be carried over government. So let this government carry out the exercise, whoever is before your lordships. That's only what I want. I'm overage. Throw me out if I'm overage. Let us know that I'm overage. Throw me out.
Inquiry has already been conducted, Lordship.
Where's the inquiry?
Lordship, that is what I am praying before your Lordship, so that I can place the inquiry report on record before your Lordship. Let me have
Sometime, Lordship. Since the matter is being pending since long, Lordship. That's why, Lordship. I'm not praying for 3 weeks or 4 weeks. I'm just praying for a 1 week time so that inquiry report I may bring it on record, Lordship.
When do you want?
After 1 week, Lordship, any date, Lordship.
Right, Mr. D. Das, Learned Senior Counsel, assisted by Mr.
RB Fukan.
R.P. Fukan, Learned Counsel. for Petition. On request made by Mr. R.M. Das, list the matter on
Lordship. 27. On 7th of March, Lordship.
seventh, this court may not be.
Okay.
Before that,
On 14.
no, 14 is too long.
Okay.
You will achieve for, let us be before that, any day. It's
As per
only a
your-
question of
as per
only,
your Lordship convenience.
yes,
Or we can have it on 12th, there's no issue.
Lordship,
12th is a hearing date.
when?
Lordship,
You want to file an affidavit
Lordship, I will.
to enable him to file an additional.
It's only, what report will how help, I don't know, my lord. How report, if they have prepared report, they not the furnish, and they will say, okay, you give, I'm telling a lordship, let them submit a report, but only what we are seeking a disposal before this on report.
That's what,
How did they have, it come, matters by a report, my lord? You have done a report, what report we also don't know. We don't know what report you have done it.
Six.
So before that, can it be before that, my lord? If it 10th, whichever, or 9th, whichever is possible, my lord.
9th or 10th.
9th, 10th, whichever, it's a matter of only few,
8, 9, 10, these are holidays.
before that, my lord. How much time report is there from dispute they have to bring, and report is they can furnish here it before this court, my lord.
That is why I'm
So,
asking
that's
on
why.
7th, Lordship. But 7th, your Lordship will be.
Well, before that, your lord, it's not
I will be
7th.
available, but.
Let it be on 5th, my lord. 5th is on Tuesday. 5th, my lord. How would this report? We'll see it, what is there in the report, my lord.
It may not be possible. May not be possible. I will try, Lordship. I will try, but may not be possible. That's why, Lord.
Oh, all, let it be on 6th. 6th is a, sorry, 5th is Tuesday, 6th. 6th. 6th is Wednesday, my lord.
I will try, Lordship. I will try. I will.
Okay, 5th. 5th.
Lordship.
Declare.
Lordship, may kindly adjourn the matter for today as my senior has some personal difficulty, Lordship.
You can request made on behalf of Mr. P. K. Mandal, the Senior Counsel. for the Petition, this the matter after 1 week.
Lordship, could it be after 5th of March? Maybe a date. 19th of March.
19th.
Lordship, interim may be continued.
Interim order possibly to continue till the next week.
Lordship.
7.
My lord, on behalf of the Guwahati University, I have filed the IA, my lord.
Hmm.
Earlier there was a stay order. So, my lord, your lordship may like to take up the IA first, my lord. Earlier stay order was passed in favor of the writ petition.
There's an order dated 9/8/2022 passed in the IA. If your lordship kindly has a look in the IA, that order, my lord, 9/8/2022. In the IA,
My lord,
IA 2241 of 2022, my lord,
if your lordship takes up that IA,
9/8/2022.
I'll have to submit first, my lord.
It says, it is stated by the learned counsel for the parties that while deciding the question as to whether to modify or vacate the interim order, the entire issues raised would have to be gone into, which may tantamount to a final decision in the writ petition. Accordingly, the learned counsel prefers that the matter be fixed for a final hearing on an early date.
Yeah. That we have gone, have you got the order 9/8/2022?
I'll provide a copy to my learned senior friend.
Today it has come in admission column, so it should come up as hearing. matter.
Whether rule was issued.
No, there is no rule issued. I mean, this is a small matter, my lord. This doesn't require an
Not
extensive
so
hearing.
small, my lord.
So,
My lord,
I'll-
So when do you want?
my lord, early hearing date, my lord.
Okay.
well, the difficulty on my part is, although there is an interim order in my favor, they are not, my lord, complying with it. So that is why, my lord, he was not ready on the last occasion, and that is why your lordship had fixed it today. And if my learned friend is ready, then we can have it today itself. I'll not
My
take
lord,
much
I'm
time.
ready, my lord, today.
Then in case you can start.
But it is,
the merit.
it has come as admission item. It should come as hearing item.
No, we can
as
have it
per
for an
earlier order.
admission hearing, my lord. What is the difficulty?
My lord, I don't have any objection, my lord.
Okay, man. In that case, I'll start. अपने फैला लो. Okay, now,
My lord.
Your lordship kindly takes, my lord, the writ petition.
Hmm.
On 17/4/2012, my lord,
Rule has not been issued as yet, my lord. It will come up
an advertisement was
as
issued,
admission matter.
page number 18.
Admission.
Page number 18.
It makes no difference,
It
admission. or
makes no
admission.
difference.
No difference.
Practically, there's no difference.
If you want a different date, I can give you a different date. That's not an issue.
My lord, your lordship may take up today itself.
Okay.
Page number 18, my lord. An advertisement was issued of the writ petition,
1 minute.
my lord.
Yes.
My lord. Page number 18, my lord. An advertisement was issued by the Guwahati University. Applications are invited from the Indian citizens for the following post in the pay band and the grade pay as shown below against the post. And serial number 5, my lord. Serial number 5 says lower division assistant. 10 post. Being eligible and interested, my lord, I applied for the said post, and pursuant to a valid selection process, my lord, I was appointed as an LDA, which your lordship will find, my lord, at page number 23. There's an office order at page number 23, my lord.
Oh.
Office order dated 21/2016, my lord. It says, with reference to their applications for the post of LDA and as per the recommendations of the selection committee in its meeting held on so and subsequent approval of the Honorable Vice Chancellor on 5/1/2016, the following candidates are engaged as LDA in office/place as shown against their names as given below. Serial number 3, your lordship will find my name, my lord. Serial number 3, Sosanko Soikia, my lord. Secretary Office, that is the place of engagement. I continued rendering my sincere and dedicated services, my lord. My services were extended from time to time. In fact, if your lordship kindly turns to the next page,
It was not a regular appointment.
not regular, my lord. But subsequently, by virtue of this honorable court's order, which I'll place, my services were regularized. I'll place that order, my lord. Well, I'll go chronologically, my lord. Page 24, if your lordship kindly turns, the next page, page 24, it says the engagement, serial number 1, my lord. The engagement is on purely temporary and on contractual basis, initially for a period of 1 year and may be terminated at any reason without assigning any reason thereof. And serial number 5, your lordship will see, the engaged candidates shall have to follow the service conduct rules applicable for university employees. So they agree that the service rules are applicable insofar my appointment is concerned. My services were, my lord, extended from time to time. And in the meantime, some of my similarly situated persons were also regularized, their services were regularized. I also prayed before them. In the meantime, what happened, my lord? On 25/9/2021, I was arrested, my lord, with regard to a criminal case. On the very same day, my lord, without even issuing me a show cause notice, my lord, they issue the impugn notification, which your lordship will find at page 38. Page 38, my lord. Page 38 is the impugn notification dated, my lord, 25/9/2021. Page number 38, my lord. Page 38. It says, this is notified for information of all concerned that the Chief Minister's Special Vigilance Cell has arrested number 1 Sosanko Saikia LDA, that is me, within bracket contractual, Office of the Secretary University Classes, and number 2 and number 3 some other persons in connection with the APDCL recruitment test. In view of the above, the service of Sasanko Soikia LDA, Office of the Secretary so-and-so, has been terminated with immediate effect as per clause 1 of the terms and conditions of his appointment order dated 21/2016. And if your lordship kindly skips to the last but second paragraph of the same page, it says, moreover, the entry of the above 3 persons is restricted inside the GU campus henceforth. So this is the stigma. This is the, my lord, level of stigma. They not only terminate me without even issuing me a show cause notice, without even giving me an opportunity of hearing, they go to the extent of restricting my entry within the campus, my lord. That is the extent of vindictiveness. And if your lordship kindly turns to the next page, page 39, your lordship will see copy for information and necessary action. Number 1 is the secretary to VC. Number 2 is secretary to registrar. Number 3 is the administrative head. Number 4 is all head of academic department. Number 5 is all office superintendents. Number 6 is concerned file. They don't serve me a copy. They don't give me a show cause. They don't give me an opportunity of hearing. They don't give me a departmental inquiry. They do nothing. They don't even give me a copy of this termination order. What do I do, my lord? I have no option. I file RTI. Page 41, my lord. I file RTI. They don't respond. Finally, they don't allow me to enter the campus. Finally, after running from pillar to post, my lord, I somehow gather a copy of this impugn notification dated 25/9/2021. The moment I get, my lord, I immediately approach this honorable court. And your lordship will see, my lord, there's an order dated 30/6/2022 passed by your lordships. There's an order, my lord, 36, which has been passed in this writ petition, my lord.
Okay.
The first order, my lord.
30?
30/6/2022, my lord. The first order. I approach this honorable court. I place the facts. I place the facts and paragraph 7. I'll only read out the relevant paragraph. Paragraph 7. Mr. So-and-so, learned counsel for the Guwahati University takes recourse to clause 1 of the terms and conditions of the engagement, which is indicated above, that the engagement of the petition will be terminated any time, and invoking such clause is to terminate it. They're taking recourse to that clause 1. They can terminate me at any time. Although the principles of natural justice has to be read into that clause, they don't do that. And next paragraph, prima facie this contention appears to be unsustainable is inasmuch as the said clause may empower the Guwahati University to terminate a contractual employee upon there being no further requirement for such contractual engagement. But in the instant case, it appears to be a penal action, and penal action always requires the procedure of law to be followed. Thirdly, the notification of termination is stated to have been served on the petitioner and the petitioner cooperating only through RTI. Any document which is not served to the person concerned and upon whom it was issued, but kept in the file of the authorities, is an honest in law. Considering the aforesaid 3 reasons on the prima facie case being made out, the balance of convenience as well as the irreparable loss that may suffer in the interim, it is provided that the notification dated 25/9/2000 terminating the petition from his engagement shall remain state until further orders. So, your lordship had, my lord, state this impugn order until further orders. They don't comply. Once again, my lord, I was compelled to approach this honorable court by means of a contempt petition, which your lordship will find at, my lord, that is listed as item number, my lord, item number 8. So I filed a contempt petition. They filed wakalatnama as, there's an item number 8. There's a contempt petition I filed, my lord. Item number 8. They filed their wakalatnama on 17/9/2022, but till date they have not filed an affidavit, meaning thereby they admit that yes, it's a willful disobedience and a deliberate disobedience of the orders of this honorable court. In the meantime, what had happened, my lord, another writ petition which I had pursued for regularization of my service, I succeeded in that, which your lordship will find. I filed an additional limited affidavit to place that on record at page number 92, your running page. Page number 92. Page number 92, it starts. running page, my lord.
Yes.
Page number 92, WPC number 5271. This was filed prior to this writ petition. 4271, serial number 3, my name, your lordship will find. Page number 92, serial number 3, Sosanko Soikia, that is me. And the order starts at page 96. Page number 96, the order starts. And relevant is, my lord, paragraph 12, page number 101.
Hmm.
101, paragraph 12, the line, 1, 2, 3, 4, sixth line from bottom in paragraph 12. The line starting from although Mr. So-and-so has submitted. Has your lordship got it, my lord? Although Mr. So-and-so has submitted the services of the petition number 3 in WPC number so-and-so, VIZ Sosanko Soikia has been terminated on the ground of committing misconduct. This court is not considered with the said aspect of the matter in the present proceedings, since the order of the termination has reportedly been assailed by him in another writ petition which is pending before this court. And the operative portion, my lord, will find at page number 104. Page 104, paragraph number 19. Paragraph number 19, my lord, it says, for the reasons stated herein above, this court is of the opinion that all the writ petitions must succeed and are hereby allowed. The writ petitions are therefore disposed of with a direction upon the respondents, more particularly the Registrar of Guwahati University, to process the case of the petitioners in light of the observations made herein above, and thereafter take necessary steps for regular absorption and or regularization of the services of all the writ petitioners by issuing necessary orders. Accordingly, the Registrar Guwahati University shall place the matter before the Executive Council of the University for taking appropriate decision in the matter and thereafter notify the same. The aforesaid exercise be carried out and completed as expeditiously as possible, but not later than 8 weeks from the date of receipt of a certified copy of this order. And my instruction is that even this order has not been complied with by the authorities as on date. That is the simple facts, man. There's nothing more. And the submissions, my lord, are primarily, firstly, my lord, no show cause notice was issued. At no point of time, my lord. No inquiry was held, no departmental inquiry. I was dismissed on the same day on which I was arrested, which shows the vindictiveness. And my lord, the procedure for dismissal of an employee is stipulated in the Guwahati University Employee Service Condition Conduct and Appeal Rules 1970, which I'll place before your lordship, my lord. So that procedure also has been violated with all impunity. So these are my basic submissions, my lord. And just a few, these are all well settled, but still, my lord, just to satisfy your lordship, there are some case laws which I'd like to place before your lordship, my lord. এখনকে দিয়েছো প্রথম দেখুন AIR 1958 SC 36. Purushottam Lal Dhingra, your lordship is aware, my lord. This is the Magna Carta. I'll just place a few paragraphs. These are time tested. Even today, my lord, Supreme Court is relying on this. My lord, paragraph 2 is the facts, my lord. May I just read out the paragraph 2? Paragraph 2. The facts are shortly as follows. In August 1924, the appellant joined the railway service as a signaller. As a result of selection, he was promoted as section controller in 1942 and as a deputy chief controller in 1947, as the chief controller in 1950. All these posts were in class 3 service. On March 31, 1951, 7 candidates, including the appellant, appeared before the selection board constituted for selecting a candidate for the post of assistant superintendent railway telegraphs, which was a gazetted post in class 2 officers cadre. The appellant was selected out of the 7 candidates for this post. On July 2, 1951, a notice of appointment was issued from the headquarters of East Punjab Railway notifying that Mr. Purushottam Lal, officiating chief controller, is appointed to officiate in class 2 service as assistant superintendent railway telegraphs headquarters office vice Sahuram, whose term of temporary re-employment expires on 3rd July 1951. The applicant actually relieved Mr. Sahuram in the afternoon. It appears that on April 28, 1953, one Gauri Shankar made certain adverse remarks against the appellant in his confidential report for the year ending March 31, 1953. This confidential report came before Shri S. Singh on May 25, 1953, who confirmed the views expressed by the Shri Gauri Shankar and added his own opinion, which is also adverse to the appellant. Paragraph 9, if your lordship kindly turns, I'll just point out the relevant paragraph, my lord. I'll not trouble your lordship with the entire judgment. Paragraph 9, my lord. In the meantime, the petitioner had on February 9, 1955, filed his writ petition under Article 226 of the Constitution. Mr. Justice Harnam Singh took the view that the petitioner had been punished by being reduced in rank without being given an opportunity to show cause against the action proposed to be taken in regard to him, and that consequently the order was invalid for non-compliance with the provisions of Article 311(2) of the Constitution. On a latest patent appeal filed by the Union of India, a division bench reversed the order of Harnam Singh and dismissed the petitioner writ application. The High Court, having subsequently certified that it was a fit case for appeal to this court, the petitioner has now come up with an appeal before us, and the question for our decision is whether the order passed by the general manager on August 19, 1953 amounted to a reduction in rank within the meaning of Article 311(2) of the Constitution. For if it did, then the order must be held to be invalid, as the requirements of that article had admittedly not been complied with. And the operative portion, my lord, will find that paragraph 37. Paragraph 37, my lord. After, my lord, considering all the submissions and all the, my lord, legal points, this is how the Honorable Court summed up. The position may therefore be summed up as follows. Any and every termination of service is not a dismissal, removal, or reduction in rank. A termination of service brought about by the exercise of a contractual right is not per se dismissal or removal, as has been held by this court in Satish Chandra Anand versus Union of India. Likewise, the termination of service by compulsory retirement, in terms of a specific rule regulating the conditions of service is not tantamount to the infliction of a punishment and does not attract Article 311(2), as has been held by this court in Shamlal versus State of UP. In either of the two aforementioned cases, the termination of service did not carry with it penal consequences of loss of pay or allowances under Rule 52 of the fundamental rules. It is true that misconduct, negligence, inefficiency, or other disqualification may be the motive or the inducing factor which influences the government to take action under the terms of the contract of the employment or the specific service rule. Nevertheless, if a right exists under the contract or the rules to terminate the service, the motive operating on the mind of the government is, as Chaglad Chief Justice has said in Srinivas Ganesh, wholly irrelevant. Now, this is most important, my lord, if a lordship kindly marks it. In short, if the termination of service is founded on the right flowing from the contract or the service rules, then prima facie the termination is not a punishment and carries with it no evil consequences, and so Article 311 is not attracted. But even if the government has by contract or under the rules the right to terminate the employment without going through the procedure prescribed for inflicting the punishment of dismissal or removal or reduction in rank, the government may nevertheless choose to punish the servant. And if the termination of service is sought to be founded on misconduct, negligence, inefficiency, or other disqualification, then it is a punishment and the requirements of Article 311(2) must be complied with. So in this case also, my lord, my termination is based on misconduct, negligence, inefficiency, or whatever. So therefore, the protection guaranteed to the petitioner under Article 302 could not have been dispensed with under any circumstance, my lord. And my lord, if your lordship kindly, if I may continue, as regards stated, if the servant has got a right to continue in the post, then unless the contract of the employment or the rule provide to the contrary, his service cannot be terminated otherwise than for misconduct, negligence, or other good. Now, this is again very important, my lord. If your lordship kindly marks this, a termination of the service of such a servant on such ground must be a punishment, and therefore a dismissal or removal within Article 311, for it operates as a forfeiture of his right, and he is visited with evil consequences of loss of pay and allowances. It puts an inedible stigma on the officer affecting his future career. In this case also, my lord, your lordship will see it's a stigma. I cannot even enter the premises, my lord. This is the stigma. This is the extent of the vindictiveness. I cannot even enter. Perhaps, my lord, this is one of a kind which your lordship had found, my lord. Generally, they terminate. In this case, they don't even terminate. They even bar my entry within the campus, my lord. And that too, without even any inquiry, without the charges, without there being any charges, without those charges being proved, without there being an, my lord, opportunity of hearing, they inflict one of the harshest penalty accompanied by a stigma that I cannot even enter into the, my lord, campus, my lord. That is the stigma. And now, if your lordship kindly turns to the next page, I'll not trouble your lordship with the entire paragraph, only the relevant lines. 2, 3, 4, 5, 6, 7, 8, 10, 11. 11th line from the bottom, the first paragraph, paragraph 37. There's a line starting from the use of expression terminate. My lord has gotten the use of expression terminate or discharge is not conclusive. In spite of the use of such innocuous expressions, the court has to apply two tests mentioned herein above, namely, number one, whether the servant had the right to the post or the rank. In my case, yes, because I had secured the employment through a valid selection process. So I satisfied the first test. And number two, whether he has been visited with evil consequences of the kind herein referred to above. Second test also I pass because the consequences are evil, my lord. It cannot be more evil than this. I am barred in entry. If the case satisfies either of the two tests, then it must be held that the servant has been punished and the termination of his service must be taken as a dismissal or removal from service, or the reversion to his substantive rank must be regarded as a reduction to rank. And if the requirements of the rules and Article 311(2), which give protection to the government servant, have not been complied with, the termination of the service or the reduction in rank must be held to be wrongful and in violation of the constitutional right of the servant. In my humble submission, my lord, both the tests I have satisfied. And therefore, this impugn order is liable to be struck down on the ground of being violative of Article 311(2), my lord. Now, my lord, this case of Purushottam Lal Dhingra has also been followed by the our Honorable High Court. Your lordship will kindly see the second case. Yes. Majid Ansari versus Union of India and others. GLT হয় এটা কিবা GAU IILD 329 GAU Monoputra. Now paragraph 2 are the facts. The lordship will see this is also a case of a temporary employee, my lord. Paragraph 2, facts of this civil rule are as follows, are as under. Petitioner is a trained motor vehicle driver having valid heavy motor vehicle. In the year 1986, he applied for the post of so-and-so in general. He was thereafter appointed MT driver in GREF on May 25, 1987, and was posted at Border Road Task Force. Pursuant to the order of appointment, the petitioner joined his service. He was posted in so-and-so. In the month of June 1988, the petitioner was served with Annexure 1 show cause notice dated June 23, 1988, issued by the respondent number 4, alleging that he was seen with one of the official carrying civilian passengers in abundance vehicle and was also calling passengers to, basically he was using a government vehicle to transport, my lord, ordinary citizens. That was the charge. And if your lordship kindly sees paragraph 7, I will only point out the relevant portion in paragraph 7. The Supreme Court in Purushottam Lal Dhingra and versus Union of India held that Article 311 gives twofold protection who come within the article. And they discuss the Purushottam Lal Dhingra and the last three lines, my lord, the line starting from but in case, if the termination of a temporary worker was not a termination simpliciter, but it is by way of a punishment, in that case, the employee would be entitled to the protection. My lord, had the respondent authorities would have said, I am not fit for the job, simple, my lord, termination simpliciter, then 311 would not be applicable. But my lord, when the termination is based on a misconduct and it puts an inedible stigma to my future prospects, then my lord, I'm allowed to be, at least the protection under 311(2) has to be granted to me, my lord. This, and if your lordship kindly sees paragraph 12, my lord. paragraph 12. That is the last operative portion. Paragraph 12. From the decision cited above, law regarding removal, dismissal, or reduction in rank of a public servant is very well settled. Even in case of a temporary worker, it is the duty of the court to see the manner and circumstances under which the order of termination was made and consider as to whether it is a case of termination simpliciter or by way of a punishment or with stigma. The order of termination or removal may be very innocuous on the face of it, but it should be the endeavor of the court to look into the circumstances under which the employee was removed from service. It can be found out from the relevant records or from the other materials, the actual nature of the order of termination. And ultimately, at paragraph 14, my lord, the appeal, the petition was allowed. And the last, I'll just read out paragraph 14. From the facts and in the circumstances of the case, it is abundantly clear that the termination of the petitioner was not a termination simpliciter, but a termination with stigma, and also by way of punishment. Therefore, procedure prescribed under Article 311(2) must be followed. As this was not done, the notice of termination, annexure so-and-so, and the discharge certificate, annexure so-and-so, cannot sustain in law. Accordingly, the annexure so-and-so termination notice and annexure so-and-so discharge certificate are set aside and quashed. The petitioner is doomed to be in service from the date of termination till he is allowed to join in service. He shall be entitled to get all the benefits as he was in service. So, following Purushottam Lal Dhingra, even our High Court has given relief. Now, my lord, my next case would be my lord DM Beliappa. Yes. DM Beliappa Home, 1979 1S system. 477. Our next call, Sujata Nath, 2019 5 GLT 774. GLT 774. Now, my lord, this is government bench space, DM Beliappa. He was also a temporary employee, my lord. Paragraph 1 is the facts, my lord. The respondent Beliappa was appointed temporary junior compositor in the grade of so-and-so in the government bench space. Now, if your lordship kindly skips to the next paragraph, the branch manager so-and-so, respondent number 1, served the notice on the respondent number on so-and-so, stating that the respondent had taken outside press copies of some ballot papers relating to director's election of food. The respondent was required to show cause why disciplinary action should not be taken against him. It was further stated in the notice that failure to comply with the notice will result in the respondent's suspension and further disciplinary action. Thereafter, on January 3, 1967, an order was served upon the respondent terminating his service. Now, this is what this Honorable Apex Court had to say. Paragraph 18. Paragraph 18, my lord. I place the facts. I'll just place the law, my lord. Paragraph 18. This is what the Honorable Supreme Court had to say with the contention. Now, the contention was made by the respondent authorities that Article 14 and 16 is not applicable to the, my lord, temporary workers. And the Honorable Court said, no, it is equally applicable. Paragraph 18, Mr. Virappa's first contention, that is for the state Mr. Virappa was appearing. First contention is that Articles 14 and 16(1) of the Constitution have no application whatsoever to the case of temporary employees whose service is terminated in accordance with the terms and conditions of the service, because the tenure or the duration of the employment of such an employee is extremely precarious, being dependent upon the pleasure and discretion of the employment state. In our opinion, no such generalization can be made. The protection of Articles 14 and 16(1) will be available even to such a temporary employee if he has been arbitrarily discriminated against and singled out for harsh treatment in preference to his juniors similarly circumstance. It is true that the competent authority had a discretion under the conditions of service governing the employee concerned to terminate the latest employment without notice. But such discretion has to be exercised in accordance with reason and fair play and not capriciously. Bereft of rationality and fairness, discretion degenerates into arbitrariness, which is the very antithesis to the rule of law on which our democratic polity is founded. Arbitrary invocation or enforcement of a service condition terminating the service of a temporary employee may itself constitute denial of an equal protection and offend the equality clause in Article 14 and 16(1). And if your lordship kindly turns to paragraph 28, that is the operative, the last part, my lord. Paragraph 28, my lord. It says, in the absence of any information from the appellant indicating that the respondent had marked out for discharge on the basis of an intelligible differentia having a reasonable nexus with the object of maintaining the efficiency and integrity of public service, we are constrained to hold that in agreement with the High Court that the impugned order suffers from the vice of unfair discrimination and is violative of Articles 14 and 16(1). Accordingly, we uphold the decision of the High Court and dismiss the appeal with cost. So, my lord, DM Beliappa says even 14 and protections under Article 14 and 16 is available to even temporary workers. And following, my lord, DM Beliappa, Sujata Nath, my lord, coordinate bench of this honorable court, 2019 5 GLT 774. I will not trouble your lordship with the entire judgment, only the relevant paragraphs, my lord. Paragraph 11. Paragraph 11, my lord. This was also a case of temporary employee. Paragraph 11 says, the Honorable Supreme Court in the case of Manager versus DM Beliappa has held that even in the case of a temporary government servant, the safeguards prescribed have to be afforded in case a penalty is sought to be imposed. So basically, this honorable court had said, even if he's a temporary employee and you want to, my lord, if they want to, my lord, terminate him, the minimum protection has to be given to him. Paragraph 12 says, in the present case, it is seen that the procedure prescribed in rules of 1964 had not been followed, rendering the impugned order of termination void ab initio. The long period of service rendered by the petitioner, which is also a relevant factor, has been totally overlooked by the disciplinary authority before passing the impugned order. In view of the above discussion, this court does not have any option but to set aside quash the order dated so-and-so passed by the CDPO project. As a consequence, the petitioner would be entitled to be reinstated in service with all notional benefits. However, adopting the principle of no work, no pay, the petitioner would not be entitled to any benefit. Now, this is, my lord, DM Beliappa has been, my lord, followed by this honorable court, my lord. And my lord, next is Pavendra Narayan Verma, 2002 1 SCC 520. I'll just point out the relevant paragraph. 2002 1 SCC 520. Pavendra Narayan Verma, my lord, paragraph 10. It discusses Purushottam Lal Dhingra. It says, paragraph 10, since Dhingra is the Magna Carta of the India civil servant, although it has found diverse judicial trends difficult to be disciplined into one single simple practical formula, applicable to the termination of probation of freshers and of the services of temporary employees, we have thought it best to refer to the facts of Dhingra's case to understand what exactly was meant when the court said. Now, a paragraph of Purushottam has been, my lord, reproduced. It is true that misconduct, negligence, inefficiency, or other disqualification may be the motive or the inducing factor which influences the government to take action under so-and-so, my lord. And if your lordship kindly skips to the line, in short, second, third, fourth, fifth, sixth, seventh line, my lord, it says, in short, if the termination of service is founded on a right flowing from the contract or the service rules, then prima facie the termination is not a punishment and carries it with no evil consequences. And so Article 311 is not attracted. But even if the government has by contract or unless the rules, the right to terminate the employment without going through the procedure prescribed for inflicting the punishment of dismissal or removal or reduction in rank, the government nevertheless choose to punish the servant, and if the termination of service is sought to be founded on misconduct, negligence, inefficiency, or other disqualification, then it is a punishment and the requirements of Article 311 must be complied with. And if your lordship kindly turns to paragraph 13, it says, paragraph 13, my lord, another constitutional bench of this honorable court in Benjamin versus Union of India and the decision of Purushottam Lal Dhingra, it followed the test mentioned in Dhingra's case. Number one, whether the temporary employee service had the right to the post or the rank. Yes, I had, my lord. I had secured that employment through, my lord, a valid selection process. As on date, my post has been regularized. As on date, my lord, my services have been regularized. And number two, whether he has been visited with evil consequences. That also, my lord, I satisfy. Such is the stigma. I am not even allowed entry into the, my lord, the campus. That is the vindictiveness. And my lord, next paragraph, paragraph 14. If punishment were restricted to evil consequences, the court's task in deciding the nature of an order of termination would have been easier. Courts would only have to scan the termination order to see whether it is ex facie contains the stigma or refers to a document which stigmatizes the officer, in which case the termination order would have to be set aside on the ground that it is punitive. In these cases, the evil consequence must be assessed in relation to the blemish on the employee's reputation so as to render him unfit or service else, whether or not in relation to the post temporarily occupied by him. This is perhaps the underlying rationale of several of the decisions on this issue. And my lord, if your lordship kindly turns to paragraph 29, it defines stigma. What do we exactly mean when we say stigma? Paragraph 29, my lord. Paragraph 29 says, before considering the facts of the case before us, one further seemingly intractable area relating to the first stage need to be cleared. What language in a termination order would amount to stigma? What do we exactly mean, my lord? Generally speaking, when a probationer's appointment is terminated, it means that the probationer is unfit for the job. When by reason of misconduct or inaptitude, whether the language used in the termination order may be, although strictly speaking, the stigma is implicit in the termination. A simple termination is not stigmatic. So if they say that the petitioner is not suitable for the job, it is not stigmatic. This is a termination simpliciter. But if they say that the petitioner is such a bad person that he should not even be allowed entry into the Guwahati University campus for his whole life, then it would be a stigma, because it imputes the petitioner above the mere unsuitability of the job. Now, if your lordship kindly sees, a termination order which explicitly states what it is implicit in every order termination of a probation appointment is also not stigmatic. The decision cited by the parties and noted by us earlier also does not hold so. In order to amount to a stigma, the order must be in a language which imputes something over and above mere unsuitability for the job. That is the test. And in our case, my lord, I had already placed before your lordship, it is out and out man and stigmatic order. And my lord, the last decision of this coordinate bench, my lord, latest decision of this honorable court, my lord. In fact, while my lord, few days ago, while moving a motion matter, I had placed this judgment also. Just because a person is temporary doesn't mean that he doesn't have any rights, my lord. Page number 8. It was a report from WPC 1785 2022. Now, the second paragraph. I'll just come directly to the point. Page number 8, second paragraph. The petitioner in this batch of writ petitions were engaged under Panchayat and Rural Development Department on contractual basis as accredited engineers, computer assistant, Gram Rozgar Sahayak. However, their services were terminated by the orders under the challenge in the present respective writ petition by giving them 1 month's salary in lieu of notice on the ground that preliminary inquiry conducted against the petitioner had disclosed irregularities committed by them in course of their service. The orders of termination have been challenged primarily on the ground that those who have been issued is in violation of the principles of natural justice. And if your lordship kindly turns to the next page, that this is how this honorable court dealt with it. The second paragraph, it is no doubt correct that in case of a contractual engagement, the terms and conditions of the contract would govern by the service conditions of the employee. In the present case, the contract agreement signed by the petitioner does not have a clause permitting termination of the contract at any point of time if the services rendered by the contractual staff was not found to be satisfactory. However, what is to be noted herein that a bare perusal of the impugn order of termination demonstrate on the face of the record that the same was issued on the basis of the findings of the inquiry proceedings conducted behind the back of the petitioner, wherein it had been projected that the petitioner was guilty of misconduct. Therefore, the order of termination of service of the petitioner dated so and so is not only based on allegation of misconduct, but the same is also stigmatic on the face of the records. In other words, the impugn order of the termination dated so and so was founded on an allegation of misconduct. However, the petitioner was not given an opportunity of being heard. Therefore, it is a clear case of violation when respondents have acted in violation of our principles of natural justice. The order of termination from service to the petitioner has the trappings of an order of dismissal removed from the court. Therefore, such order could not have been passed without giving an opportunity of hearing. This is for the simple reason that such an action, besides causing serious prejudice, would also have a bearing on the prospect of his future employment. And accordingly, my lord, the termination order was set aside. And my lord, there are rules, Guwahati High Court rules. Before I place the rules, I'll just place one page before your lordship. I'll place my appointment letter, page number 24. Page number 24, serial number 5, my lord. Page number 24, my lord. This is my appointment letter. Serial number 5. Serial number 5. It says, the engaged candidates shall have to follow the service conduct rules applicable for university employees. That means they don't, they agree that these conduct rules are applicable in the present case. Now, if your lordship sees, my lord, there's a rule in the rule, section, my lord, internal page 22 at the bottom. Page number 22 and 23. This is Guwahati University Employee Service Condition, Conduct and Appeal Rules 1970. My appointment letter itself indicates that these rules are applicable. Page number 22, nature of penalties are prescribed. And Rule 46A enumerates dismissal from service which shall ordinarily be disqualification for future employment. Now, in my case, it is not only a dismissal from service, it is also, my lord, barring me from future employment. And also, my lord, I cannot even enter the premises. That is the vindictiveness. And if your lordship kindly turns to the next page, your lordship will see, my lord, Rule 48, procedure for imposing penalties. Now, the procedure says, no order imposing on an employee any of the penalties specified in Rule 46. Now, mine was a penalty under Rule 46. Shall be passed except after an inquiry held as far maybe in the manner herein after provided. More or less, my lord, this is a replica of Article 311(2), my lord. No person shall be removed or reduced in rank except after an inquiry in which he has been informed of the charges. And number 2, my lord, disciplinary authority shall frame definite charges on the basis of the allegations on which the inquiry is proposed to be held. Such charges together with a statement of allegation on which they are based shall be communicated in writing to the employee, and he shall be required to submit within time as may be specified a written statement of defense and also whether he desires to be heard in person. So, number 1, my lord, there has to be an inquiry. I cannot be dismissed from service without an inquiry. Number 2, my lord, they shall frame definite charges, my lord. And I should be allowed to file a written statement whether I admit or, my lord, rebut any of those charges. Number 3, my lord, the employee shall, for the purpose of preparing his defense, be permitted to inspect and take extracts of the records. Number 4, my lord, on receipt of the written statement of defense, if no such statement is received within a time, the disciplinary authority may itself inquire into the charges. Number 5, my lord, the inquiry authority shall in course of inquiry consider such documentary evidence, take oral evidence, and all that. The employee shall also be entitled to cross-examine witnesses, my lord. Number 6, my lord, at the conclusion of the inquiry, they shall prepare a report and with the findings, and I should be given a chance. Well, that ECI, basically that ECIL judgment, my lord. So all the, my lord, all the procedure has been prescribed. And number 9, your lordship will say major penalties. It says, number 9A, if the disciplinary authority having regard to its finding on the charges is of the opinion that any of the penalties specified in clause 10 to 8 of rule should be imposed, shall number B, furnish the employer report of the inquiry. Number C, give him a notice stating that the penalty proposed to be imposed and calling upon him to give a representation. And number D, well, basically all the procedure has been described. And in my case, my lord, none of all these procedure have been given a total go by. So, my lord, to sum up my submissions, my lord, my submission is basically a 5-point submission. Number 1, no show cause, my lord, at any point of time intimating me the charges. Number 2, my lord, no inquiry has been held. I was arrested on 25/9/2021. On the same day, they terminated me, my lord, with an extremely stigmatic order. Number 3, my lord, the procedure which has been, I have placed, procedure under Rule 48 of the Guwahati University Employees Service Condition Rules have been violated with all impunity. And, my lord, the conduct of the authorities as on date, there are two orders of this Honorable High Court. One which has stayed the impugned order, and number two, my lord, the other order where my services have been regularized. Till date, both the orders have not been complied with by the authorities. So the conduct of the authorities clearly smacks of malafide, my lord, and the vindictiveness is apparent on the face of the records, my lord. But in sum and substance, that is my argument, my lord. Subject to what my learned senior friend says, my lord. I reserve my right to rebut, my lord. That is.
May I please? Lord, I'll be very brief, Lord, but there are some complicated aspects of the law in the entire matter. So first, Lord, the Constitution, Article 311. On devotion. Article 311. May I read it? No person who is a member of a civil service of the Union or an All India service or a civil service of a state or holds a civil post under the Union or a state shall be dismissed or removed by an authority subordinate to that by which he was appointed. 2. No such person as aforesaid shall be dismissed or removed or reduced in rank except after an inquiry in which he has been informed of the charges against him and given a reasonable opportunity of being heard in respect of those charges. Now it is important. Provided that where it is proposed after such inquiry to impose upon him any such penalty may be imposed on the basis of the evidence adduced during such inquiry, and it shall not be necessary to give such person any opportunity of making representation on the penalty proposed. Now, provided further that this clause shall not apply. A. Where a person is dismissed or removed or reduced in rank on the ground of conduct which has led to his conviction on a criminal charge, or it is applicable, Miller, this B. Enquiry could be dispensed with, Miller. Where the authority empowered to dismiss or remove a person or to reduce him in rank is satisfied. It is important, Miller. Is satisfied that for some reason to be recorded by that authority in writing, that reason should be recorded, Miller. It is not reasonably practicable to hold such inquiry. And since the regarding governor president, it's regarding national security, that aspect. So, Miller, that proviso B of the Constitution, Article 311(2), it clarifies that this clause shall not apply. Means inquiry could be dispensed with if it is not reasonably practicable to hold such inquiry. This is one aspect, my lord. I'll be very short. Now, General Clauses Act. Just 3 legal provisions, my lord. Then I will revert back to the facts and then judgments. General Clauses Act 27. It is pertaining to the service of termination notice. Paragraph 27. Meaning of service by post. Where any central act or regulation made after the commencement of this Section 27, General Clauses Act, regarding service of notice by post. It is in the context of not receiving the termination order by the writ petition. First one regarding dispensing with the inquiry. And the second one regarding non-receiving of the termination order by the writ petition. meaning of the service by post, section 27 million. Where any central act or regulation made after the commencement of this act authorizes or requires any document to be served by post, whether the expression serve or either of the expressions give or send or any other expression is used, then unless a different intention appears, the service shall be deemed to be effected by properly addressing, prepaying, and posting by registered post a letter containing the document, and unless the contrary is proved to have been effected at the time at which the letter would be delivered in the ordinary course of post. That postal delivery, my lord. That is the main crux, my lord, of that section, my lord. Now, regarding Guwahati University Act, my lord. Section 44.
Rules or act?
Act, my lord. I've got the University Act, my lord, the last page. It was amended in 2013. Section 44(1), my lord. May I read, my lord? 44(1). The university shall establish and maintain the teaching and non-teaching staff ratio at 1:1.5 progressively. In order to establish this teaching and non-teaching staff ratio, the university shall not appoint, it is important, my lord, the university shall not appoint any non-teaching employee afresh against sanctioned vacant post, and also shall not initiate for re-employment of any retired person upon their retirement without taking prior approval of the state government. They are temporary, the writ petitioner is a temporary employee, contractual employee. My lord, along with some others, they have preferred writ petition before this honorable court. Honorable court passed order to regularize their services and placing the matter before the executive council. And against that order, a writ appeal has been preferred, my lord. That is still pending on the basis of this section 44(1). Since the state government is necessary party, the budget allocation and other things are there. And as per section 44(1), prior approval of the government is required before regularization. So, my lord, that writ appeal has been preferred. It is still pending. Their services have not been regularized as yet. And more importantly, his service is no more since 1st January 2022, more than 2 years back. I'll come back to the factual, my lord, situation, my lord. Your lordship may take up the IA, my lord. That will be better, my lord. The IA, interlocutory application number 2241. Only one IA is there. I take your lordship straight to page 12, paragraph 9. Page 12, paragraph 9. Three, 4 pages, my lord. That will sum up my contention, my lord, regarding factual aspect. May I read, my lord? Paragraph 12, paragraph 9, page 12. That the applicants humbly beg to state that in the pertaining factual matrix, the writ petitioner has willfully suppressed as well as misled this honorable court as regards the following material facts having vital bearings in the instant writ proceeding. 1. Next page. I will read slowly. That the writ petitioner has stated in the writ petition that as on date, the petitioner has not been officially communicated about his termination by the officials of the university. Paragraph number 15 thereof. And since till date, no response has been forthcoming from the authorities in respect of his RTA application dated so and so regarding not allowing to work in his post. The situation purportedly has come to such a pass that it is only after running from pillar to post that the petitioner could now somehow procure the aforesaid impugned notification dated 25/9/2021 from reliable but unofficial sources, paragraph number 16 thereof. Now, Miller. However, the formal and due approaches of the Guwahati University authorities on several occasions, including speed post communication of his service termination notification, speed post communication of the RTA response, physical and personal visits to his house as regards keys of the official almirah have been negated. These having been culminated with either door locked or out of station or not available stage or got refused on the part of the writ petitioner and or his family member, relevant records of postal reports as well as the Guwahati University staff's reports may be referred to. I have annexed, Miller, the postal report, Miller, regarding refusal of that termination order letter. Next line, Miller, last line. It is humbly stated that these, next page, Miller, page 14. These approaches of the university authorities are in tune with the relevant practices as well as existing laws of the land, including the Assam General Clauses Act 1915. It is perimeteria with the Central Act of 1897, General Clauses Act. Your Lordship has just gone through section 27. Further, the writ petitioner is well versed in computer arena. It is also important. Writ petitioner is well versed in computer arena. Paragraph number 5 and 6 of the writ petition may be referred to. And being a computer savvy person who has been actively engaged in computer related works in the university, it is strange that he has been selectively unaware about the termination notification, which is still available in Guwahati University official website. The termination order is available in the Guwahati University official website. And he is a computer savvy person as per his own statement in paragraph 5 and 6 of the writ petition. Now, next para, sub para 2, Miller, page 14. That the response communication of the PIO of Guwahati University as regards the writ petitioner's RTA application dated so and so has also been refused to be received, though it has been projected by the writ petitioner that there is no response. It may be pointed out here that though there has been purportedly no response to his RTA application, the writ petitioner has not submitted any appeal for the same under the provisions of the RTA Act, which is the normal practice under the existing circumstances. No appeal to that RTA petition has been filed as yet. Now 3. That the writ petitioner was granted bail by this honorable court on 18/11/2021 in BA number so and so, which has not, it is important, Miller, it is suppression of material facts, Miller, and misleading this honorable court. I'll place the judgments later, Miller, which has not at all been indicated in his writ petition, next page, Miller, and has chosen to bid his time till the expiry of his extended term of engagement, devising and plotting a crafty game plan, and ultimately has approached the university authorities much later with an RTA application dated 2/3/2022. His term, Millard, was extended up to 31/12/2021. He approached with RTA application in March 22, and he approached this honorable court on 27th June 2022 with this writ petition, Millard, after long 6 months. Anyway, Millard, now next subpara 4, page 15. That the writ petitioner has stated in the writ petition that he is not even allowed to enter the Guwahati University campus, and that even his entry within the Guwahati University is barred, paragraph number 17, 18, and 19 thereof. On the other hand, The writ petitioner has personally visited the office chamber of the registrar and submitted his representation dated 1/7/2022 along with this honorable court's stay order dated 30 June 2022 without any objection from the university authorities. In fact, the writ petitioner's entry in view of the prevailing circumstances has been restricted only and not barred as erroneously projected by him in the writ petition. Now 5. That a writ petitioner has not made any whisper in his writ petition that his term of contractual engagement was extended on 27 July 21 only for 6 months, and as such his service was no more with effect from 1/1/2022. It is important, my lord. His service was no more with effect from 1st January 2022. He preferred RT application in March. He preferred writ petition in the last week of June next year. Paragraph 10. Same page, my lord, last 2 lines. That the applicants humbly beg to state that as per the office order dated 27/7/2021, the writ petitioner's term of contractual engagement, next page, my lord, was extended for another period of 6 months with effect from 1/7/2021, and therefore his service term was to expire on 31/12/2021, and the writ petitioner was no more in the service of the Guwahati University since 1 January 2022, which aspect has not at all been indicated by the writ petitioner in his writ petition, consequently suppressing a vital material fact from this honorable court. On the other hand, service termination notification has also been issued with effect from 25/9/2021. Next parameter. At the time of passing that stay order, these informations were not available to the my lord university's council. So that is why, my lord, that stay order was passed at that time, my lord. Anyway, my lord, since it is now hearing stage, my lord. Next page, next parameter. As such, the matter has already become infructuous. The writ petitioner, having been out of the service long back, without any discernible as well as conscious effort to move against the said termination in any forum, including this honorable court during the relevant period, and in view of the instant factual and legal metrics, it is humbly stated that this honorable court may not like to issue a futile writ. It is important. It is humbly stated that this honorable court may not like to issue a futile writ, exercising the power under Article 226 of the Constitution in the instant matter. Now, with this factual backdrop, my lord, I'll now place before your lordship first the notice served under Section 27 of General Clauses Act, Supreme Court's judgment of 1992. There are several judgments. I think it would be sufficient, my lord. Paragraph 9 and 10.
Before you place the judgment
My lord.
on the factual area,
My lord.
now you have to convince this court.
My lord.
See, the termination order
My lord.
was issued on
25/9/2021.
My lord, may I take your lordship, my lord, to the termination order itself, my lord? That will be better.
page 38.
Is my IA, my lord, interlocutory application. That will be better. 3-4 pages. I should have shown before, placed before your lordship, my lord. My IA. First, my lord, that page 19 and 20, Annexure 1, that appointment order. Annexure 1, page 19 and 20. Initial appointment order. Kindly turn to page 20, my lord. It is important, my lord. The engagement is subject to the following terms and conditions. 1. The engagement is on purely temporary and on contractual basis. It's very important, my lord. Engagement is on purely temporary and on contractual basis initially for a period of 1 year and may be terminated at any time. These two phrases, my lord. My lord, in Sri Lanka, my lord, Supreme Court, my lord, explained at any time without assigning any reason thereof. Some public prosecutor of UP has been terminated, my lord. Advocate General appeared, and after that, my lord, Supreme Court explained at any time and without assigning any reason thereof. And my lord, other terms and conditions we can skip, but one term, my lord, I should, my lord, at least place before your lordship. Four, my lord, term and condition. The first one is temporary and contextual, may be terminated at any time without assigning any reason thereof. Now, 4. The engagement is subject to getting the character and antecedents to be verified from the police authorities. The police authorities arrested him. He was behind the bar and he was terminated. My lord, I'll go back to the factual position a little later. Now, my lord, kindly turn to page 21, next page, my lord. The last extension order, my lord. Earlier one was of 2016. Now it is of 2021. I have mentioned in my IA. The third one, Sasanko Soikia, office order. As per approval of Honorable Vice Chancellor, Guwahati University, the term of engagement of following LDAs on contractual basis is hereby extended for another period of 6 months with effect from date as mentioned against their name. Third one, Sasanko Soikia, the writ petitioner. Place of engagement, Secretary Office, date of effect 1/7/2021. So, my lord, 6 months will be over on 31/12/2021. From 1st January 2022, his service is no more. It has not been extended till date, my lord. Now, next page, my lord. This is the impugned notification of termination. I'll read it slowly, my lord. Paragraph, my lord, page 22, Annex 3. This is notified for information of all concerned that the Chief Minister's Special Vigilance Cell has arrested 1. Sri Sasanko Soikia, LDA Contractual, Office of the Secretary, University Classes, Guwahati University. 2. Sri Tridip Sharma, so-and-so. 3. Sri Babylon Kakoti, so-and-so, in connection with the APDCL recruitment test. Next para. In view of the above, the service of Sri Sasanko Soikia, LDA, Contractual, Office of the Secretary, University Classes, Guwahati University, has been terminated with immediate effect as per clause number 1 of the terms and conditions of his appointment order dated 21/2016. That page 20, my lord. He could be terminated at any time without assigning any reason thereof. And it's purely contractual and temporary. That clause 1. Further, so-and-so, also security agency so-and-so. Now, these 2 paragraphs, last 2 paragraphs. Moreover, the entry of the above 3 persons, including Sasanko Soikia, my lord, is restricted inside the Guwahati University campus henceforth. It is because of that APDCL recruitment test, my lord. Some situation was there, my lord. Everyone was in doubt, my lord. Who has committed which one, my lord? In the media report.
What happened to the other 2?
My lord, I don't have the present, my lord, information, my lord, but possibly they are in the bail, my lord. The bail order has been granted, my lord, possibly, my lord, in favor of them. My lord, that bail order, it was, my lord, several applicants.
When was the petitioner arrested?
Arrested same day, my lord,
25/9.
25/9/2021.
Where can I get that?
My lord,
I have pleaded, my lord. Paragraph 13, page 7 of the writ petition
Just on pleadings.
on pleadings.
in fact, he was arrested the day before on 24/9, but the order has been issued on 25/9. The last line, this is issued with the Honorable Vice Chancellor's approval dated 25/9/2021. Now, just one page, my lord. I'd like to place page 27. This notification has been sent through speed post as per section 27 of General Clauses Act. Page 27, my lord, there are some other pages also, my lord. Kindly see the first in handwriting, my lord, by the postal staff, refused. Page 27, Annexure 6. It was dated 7/3 of that year, my lord, 7/3/2022. Earlier absent. Second one, some noticed, and now last refused. That postal communication along with this termination order has been refused. my lord. Now, if we come to the Jagdish Singh case judgment, my lord, regarding,
No, no, I'll allow you to,
my lord,
let me be very clear on this.
about
as
the
well.
facts, my lord,
So on the termination, I'm coming back.
my lord.
Now, this court has to consider the language of the termination,
Yeah.
right?
This
Now you
honorable court will
have read Article 311(2)
my lord,
and Proviso B.
proviso B.
Now it says if it cannot be
Not
In court.
reasonably practicable,
not reasonably practicable, it has to be put down in writing.
my lord.
Have you done that?
Yes, the reasons must be there. My lord, I will place Tulsiram, the celebrated case of the
No,
constitution.
Tulsiram
My lord,
will
my lord, I will go to that aspect later, my lord.
Oh.
First, to apply Article 311 to Proviso B, there should be reasons.
recorded
Reasons should be recorded
in writing.
that in writing. That is the paragraph number 1. Paragraph number 1, that the Chief Minister's Vigilance Cell has arrested the writ petitioner regarding that epidecial scam. Paragraph 1. Paragraph 2, he has been terminated with immediate effect.
No, read the 311,
Yes, my lord.
311 properly.
I have read it multiple times, my lord. In another case, my lord, that was judgment was reserved, my lord, in Rudrachandra Das, a grade 4 employee of Guwahati University. Same situation, my lord, without
See,
inquiry.
311B.
311 B. May I read slowly, my lord?
2B.
2B. Provided further that this clause shall not apply regarding holding of inquiry. Where the authority empowered to dismiss or remove a person or to reduce him in rank is satisfied, that, it is important, my lord, is satisfied that for some reason, comma, that reason, comma, to be recorded by that authority in writing. That reason should be in writing. That arrest by the CM's vigilance cell in connection with epidecial scam. That reason is there, the first paragraph. Now, comma, to be recorded by that authority in writing, that reason. It is not reasonably practicable to hold such inquiry.
That is what is required.
No, Miller, it is not reasonably practicable to hold such inquiry.
That has to be put in writing.
Miller, it is regarding reasons, only reasons.
No. Read it properly.
Miller, I will again, Miller, read. For some reason, comma, to be recorded in writing by that authority. By that authority, that reason must be in writing.
By that authority.
Yes, my lord. Then comma, my lord.
It is not.
There is an importance, my lord, that comma has been put, my lord, twice. First, for some reason, comma, to be recorded by that authority in writing, comma, over, reason to be recorded in writing, comma, over. Now, it is subjective, my lord, satisfaction, it should be. My lord, the other clause 3 will clarify, my lord. After comma, it is not reasonably practicable to hold such inquiry.
That is what is recorded in the note sheet or the whatever you call it.
Affidavit. At least in the affidavit, they've never taken this.
No, in the record that should be there, that it is not it is not reasonably practicable to hold an inquiry
Milord,
for so and so reasons.
that was not the intention of the Milord Parliament, Milord, while Milord putting this, Milord.
That this court
Right.
will interpret. That this
Milord, if there are two views, Milord, I will go to the two views concept little later, Milord. If we, Milord, in literal sense, we go to the meaning of that comma. For some reason, comma, to be recorded in writing. Why not this reasonably practicable to hold such inquiry? That line has not been put before that comma, Milord. That line has been put after comma. May I read again, Milord? For some reason, to be recorded by that authority in writing. That reason should be in writing, not that satisfaction, Milord. That 5 judges constitution bench is clear regarding that, Milord. Now kindly read the clause 3, Milord. Milord, Milord, article 3. If in respect of any such person, next 3, Milord, as aforesaid, a question arises whether it is reasonably practicable to hold such inquiry as is referred to in clause 2. The decision thereon of the authority empowered to dismiss or remove such person or to reduce him in rank shall be final. It is not regarding writing that satisfaction, that we are satisfied, so we are going to terminate the employee. It should not be there, but the reason must exist. That reason must be in writing. Thereafter, that comma has been put, Milord. Otherwise, that reasonable satisfaction phrase, it should be before that comma. It is interpreted. Yeah, and
let us assume you are correct.
there are two views.
Let us assume you are correct.
Then if two views are possible, this constitution bench is also clear.
Let us see.
This, Milord. So that is why, Milord, I will go to the judgments one by one, Milord. There are 5, 6 judgments, Milord.
No, that's why I want to be very clear on the facts.
Milord.
That is one thing you are saying reasons is given in paragraph 1.
Milord.
This court does not agree with you
Milord.
because this court is of the view that the reasons has to be given in your records.
For the argument's sake, Milord, I also accept there are two views. One view
Okay.
as propounded by
Okay,
this honorable.
that's fine.
Milord.
We keep it at that stage.
Milord. Now, Milord.
Now the other two is, next question is,
Milord.
now what happened to the other two persons?
Milord, since they are not before your lordship, I don't
No,
think.
no, this court wants to know. Because
then-
the offense is the same.
Milord. But they are not Guwahati University employees.
No, one of them
Milord,
is,
no, Guwahati University,
one of them
but
is,
Tridip Sharma,
Tritiv is ITI,
ITI,
but number 3,
and 3 security Babylon Kakoti, security in charge,
that is Guwahati
group
University.
5 placement and security services. It is a hired service concern, Milord. Anyway, Milord, if we, Milord, accept that these 3 are employees of Guwahati University,
No, maybe 2.
maybe 2,
Maybe
Milord.
2. The
But
second
right
one,
at this moment, Milord, I don't have any clear information regarding those 2. They are paid, Milord. Possibly my learned friends will.
I don't know because I'm not representing them, but perhaps employee number 2 is an employee of ITI Limited, which
that's what I'm saying.
and
But number 3,
number 3 is a security in charge and employee of group 5 placement and security service. Perhaps the private security, perhaps.
no.
That has been hired.
Read para, the last third para.
Also, the
Security agency.
agency group 5 placement and security hereby from terminate Sri Babylon Kakoti with immediate effect.
That security agency has been informed to terminate.
He's hereby informed to terminate. So perhaps these 2 are perhaps
Little
my
bit.
lord.
Regarding other 2, Milord, since this honorable court is seized with the writ petitioner's case, Milord. So, Milord, and if required, Milord, I will place the concrete information, Milord. And
See, it happened on 24th, according to you, correct?
yes, Milord, 24th night.
24th night, 25th morning, you issued the order.
Not morning, my lord.
or whatever it is.
24.
On
Let us say
25th, my lord.
25th you issue.
Within 24 hours, my lord,
Within
I
24
presume.
hours you give.
Terminate.
Whether it is valid in the eyes of law.
This is what this
Yeah.
will have. to
Me-
be. And number, in the terms and conditions of the appointment order,
Yeah.
it's say number 5.
Hmm.
It provides that
Hmm.
you will follow the Guwahati University conduct rules.
Correct.
Correct.
My lord.
Correct.
My lord.
This is there.
Whether,
My lord,
whether
that
you-
penalty could be imposed.
whether you followed the conduct.
Yes, my
rules.
lord. It is to be read with that Article 311.
So Article 311, we are keeping it aside for some time.
My lord,
To have a
article,
look at the
the
two views.
constitutional provisions will prevail, my lord. That hierarchy,
That will prevail.
Celson's hierarchy, my lord, as
There's a
my lord, first
There are
constitution, then
number of judgments which says records has to be recorded, reason have to be recorded.
recorded, my lord. So, my lord, may I place that?
Yes, it's up to you. If you want to place it or if you want to get the information and come back, I can keep it parted and list on some other day.
Oh, my lord, that will be better if your lordship insists regarding that, those
Otherwise-
other two.
Yeah, other two and the
I
other,
don't have any concrete
and
information.
I also want to see your records.
Maybe some bearings will be there, my lord, relevancy regarding those other two. If they also moved this honorable court with other writ petition, other orders, coordinate bench, then, my lord, that should be considered, my lord.
Yes.
I think, my lord. Being a counsel, I am also a legal law
Obviously,
officer, my lord. I should, my lord, place proper facts, my lord. So, my lord, another date. For date, my lord, any Tuesday, Thursday.
the matter
It may
has
be treated as part, I don't have any objection.
Take a Barwal and a counsel for the petition. Also, at least a PF call and accidentally counsel got. For the response. List for 48. Maybe next week there will be some difficulty on
Okay,
the
ma'am.
part of this.
Any date, as per your lordship's convenience, any hearing date, my lord.
We'll have it on 14th March.
What not?
By that time, I think you should have sufficient time to come.
14, can it be on
12?
21, my lord? Next,
19th, my lord. Let it be on 19th.
not
21,
19, 21.
এই সব, একটু সব মূল হেৰি, 19th লৈ লওক। বা 14 তাৰিখে লৈ লওক।
On 19, my lord.
19.
On 19 Tuesday.
On that, on the next general date, the standing council for the university shall also produce the records in original. You produce the records also, we'll see.
My lord.
But it may come as a part heard matter.
As part of.
Deeply obliged, man.
Most obliged.
Deeply obliged. Obliged.
Give me one of this. Huh? Oh, okay. Oh, this one also. Yeah.
Item 9.
Yeah, please, your lordship. This matter will take some time. Lordship may kindly fix this matter in the next week or any other week, lordship. Yes,
I leave it to you. Then should I issue rule?
no, lordship. It's a small matter, lordship.
Okay, on request made by the parties. List on when? 12th,
12th, yes, lord.
go good.
Highly obliged.
Yeah.
In this matter, on last two occasions, my lord,
Hmm.
they were directed to bring the instruction regarding the appointment letter, my lord. Here the petitioner has successfully cleared.
What
It-
instruction?
I have received, my lord. Regarding percentage of his disability. I have received it, my lord.
1 minute.
Last paragraph. madam. Thereafter, the department by letter dated 8/11/2023 informed the Standing Council TNRD Department, Guwahati High Court that Sri Muktinath Dole, as a petitioner, had 23% PWD ENT. He could not be considered for appointment under PWD hearing impaired category for the post of BDO. That is the Malan instruction. He is not 40%, less than 40%. So benchmark is 40% is required to be appointed as a district. He is only 23%.
I have annex one, annex, there is page number 32, annex 3, my lord. Yeah, this is hearing impaired, disability is 50%. Some date of birth and disability percent is 50% is there, madam.
Where? Where's your disability certificate?
Disability, yes, yes, my lord. Yeah, date of birth is right and that middle.
Where's your disability certificate?
My lord, I have finished. It's not there, my lord. But let them file affidavit, my lord, on the.
That is your whole crux of the matter.
Yes.
You're
what
claiming
affidavit
your
is ready?
disability on the basis of disability certificate.
Yes, my lord, there is a page number 19 and next 1, my lord.
Page number 19.
Yes, my lord, and next 1. Certificate for the persons with disability, my lord, here. In the last certificate, PC. One second, fifth line, my lord. Heading this will as the 50%, my lord.
It's a permanent disability.
No.
Yes, yes, my lord,
Partial.
50, no, 50%.
C. Read C.
It's the hearing disable and has 50% permanent disability in physical impaired. Here is the permanent disability, my lord. 50% permanent disability. Temporary physical is already cut the hearing impaired.
Then you file your affidavit. Third, Mr.
A borrow, my lord.
A. Borol and counsel of the petition. Mr. T.C. Chutial and additional senior government advocate submits that he has received instructions and pressed for a short time to file counter affidavit. The file affidavit.
To bring on the instruction on affidavit, my lord.
That he has received, don't say that he has received instructions as directed by this court. And therefore, placed for a short time to bring this their instructions
on
by way
record.
of an affidavit. List the matter after.
After 2 issues.
After 2 weeks.
Okay. There is an interim order that may be continued.
What interim is the
Not to fill up the, to keep to one post.
interim order passed earlier to continue till the next?
Publicly.
Published, my lord.
12, hearing.
Pray for an adjournment. The matter supposed to be done by Mr. the senior counsel. And he is now bedridden, my lord, and the original file is in his chamber.
Who's your counsel?
Bisida.
BC. Okay, on request made on behalf of Mr. Bisidas, senior counsel
Yes, ma'am.
for the senior counsel for the petition. When do you want?
After 2 weeks.
After 2 weeks.
Published.
13,
Let's this matter be taken up another day, my lord. Preferably on 14th of March, my lord.
Another day.
My lord.
14 March.
14 March or
Huh?
14 March.
ঠিক আছে। It doesn't. Oh, Lordship, there is some other matter fixed on 14th. If it can be on any other day, Lordship. 15th is fine. Lordship.
It's a Friday.
No, 15th. Let it be on 19th, Lordship.
19 I have some problem.
14th series at a fixed.
12 vote can go on.
12.
12 March, my lord.
Yes.
Okay, on request made by Mr. S.R. Abal and counsel for the petitioner. This the matter on 12th March.
Obliged.
14,
May I please your lordship, my lord? In this case, my lord, the petitioner, my lord, who has been selected as Gambura, my lord, for appointment with Gambura. So his appointment matter has been appealed, my lord, in the appeal, my lord, that is before the Lower Assam, Learned Commissioner, North Division, Assam, Tezpur has set aside here the selection of the petitioner, my lord. And private respondent number three has been selected. On the basis, on the question is here, my lord. I obtained 65 marks. He obtained 5 marks. On merit, I am well above. Here, my lord, the learned Commissioner North Assam Division, my lord, what he did that as per rule, my lord, is a preference to be given. He is a family member of the Gambara, so preference. Well, when preference will come? Preference will come when both are on the same footing, my lord. Then he should be given the preference to me, above me. Here I obtained 65 marks. He obtained only 39 marks. Then how my appointment has been set aside? And that is the.
I have received records, my lord. I will have to go through it, my lord. Let it be next week, my lord. I will go through it to assist the court.
I
I received the records.
If what he says is correct, that petitioner got 65 in the other party got 39.
It's a 39.
Definitely, lordship will
Then
pass an order.
then appropriate orders will have to be
Yes,
passed.
yes, my lord. I will go
The
through.
private respondent, you have a private respondent?
Yes, yes, they will appear.
You are appearing, Hendrik, you are appearing?
I'm for the revenue department, lordship. Respond number 1.
Is the notice has been served?
Yes, yes, they appear.
Pleading has been complete.
They have also filed their reply also.
Who's the counsel?
Private respondent, my lord, R. Borua, M has been so.
Okay. What, Mr.
Yes, so my name is A. Chaudhary.
H. Hazard, H.
A. Chaudhary.
Oh, H. Chaudhary and counsel for the petition. On request made by Mr. T.C. Chutiel, the additional senior government advocate. When do you want?
After 2 weeks, my lord.
This the matter.
My date.
2 weeks. Okay, 14th March.
All right.
14. Obliged.
16,16,
Anybody appearing for respondents?
I'm for the comment. I'm for the respondent.
None appears for the petitioner. Mr. J.K.
Barajuli.
Barajuli, Leonard's government advocate, appears on behalf of the
Perhaps state respondent.
of the state respondents. List after 2 weeks.
17,
Look, in this case, the previously, my lord, the pleadings were filed in complete, my lord. There was a different counsel for the bank, but pursuant to the filing of pleadings and during the petition, particularly in 2023, certain developments have been done, which will affect, his right, their right. Rather. But the issue is very simple. The issue is relating to the computer increment, also known as fixed personal pay. Now, during the pendency of the petition, my lord, in 2023, the government of India has issued an office order to all the regional rural banks, including this respondent bank, my lord, making the FPP payable from 1/4/2018, 1st of April 2018. And my lords, we have already started paying that also. That is not disputed. But to place that those relevant facts, I will have to take some time to file an additional affidavit. But I'll serve him a copy. Thereafter, matter may be taken up. Because there is a dispute, my lord, this issue has been agitated in number of high courts, reached the Supreme Court 1 or 2 times. And even now, my lord, as far as the pension and other payments are concerned, contempt petition is pending in the Supreme Court. So, my lord, this is not an issue which perhaps should be decided without, my lord, the relevant pleadings on record. The Lordships will permit me liberty, my lord, 3 weeks
Okay,
time.
heard Mr.
Sharma.
R. Sharma, learned counsel for the petitioner. On request made by Mr. A. Ganguly, learned
Lord.
counsel, standing counsel
Lord,
for the respondent bank. How much time will require?
Lord, 3 weeks.
List the matter up to 2 weeks.
3 weeks.
Or the cancel it. Mr. A. Ganguly, learned standing counsel for the respondent bank, submits that during pendency of this writ petition, certain developments have taken place, and he prays for 3 weeks' time to place the same by way of an affidavit.
Additional.
By way of an additional
That may be fixed.
prayers allowed. List on when?
Let it be in first week April.
4th April.
18,
This case relates to, my lord, from discharge from service, my lord. The petitioner was working in the Assam police, my lord. Then he was discharged from service, my lord. Affidavits have been filed, my lord. Pleadings is complete, my lord. If lordship permits, I can start the hearing, my lord.
Yeah. How long will you take?
But not more than 10 minutes, my
Chitya?
lord. Almost 4, my lord.
That's why I'm asking you.
Not possible. I have received the record also. I will have to go through it. Next week. Only there is a petitioner is discharge, whether discharge is applicable or in the terms of
Because-
penalty or not. That is the one point, man. Because under the Assam police manual, there is no concept of discharge. Man. There is a covered case. There is a judgment of this High Court itself. In a case where a police personnel was discharged from service, the High Court has said there is no concept of discharge. Man. So my appeal is concerned. Man. Appeal is disposed of because there is a time bar. Lordship direct his authority to admit the appeal. They can dispose of the matter. Only 2 line till end order. That can be done, my lord. Dispose of the petition, my lord, with a
You
right.
want to go on merits or you want your appeal dispose?
If they decide the appeal on merits, I do not have any objection, my lord, because they decided on the issue of time bar, my lord. Yes, time bar. If they decide on merits, I do not have any objection. Then if they decide to take a fresh decision, I have no objection, my lord. Lordship directly on merits, if they decide, my lord. It's simple issue, my lord. If it is remanded on the issue of merits by
Yes.
the appellate body, my lord. Yes.
Where's your dismissal of your appeal?
Appeal dismissal order, my lord. Next, sir. 11. Impure order is at page 50. The discharge order is page 32. Annexure 6. This is the first order. First order. 13 to 2017. Yes. Yes, this is the first order. 11% 33.
Then
Then I filed my appeal along with a delay condonation, and
How many days delay?
Delay, my lord. 11 days. Next one. 816 days.
800.
816. It was accompanied with a delay condonation application.
But 816 days is quite long. How can I send it back?
Because my lord,
No, February 17, yes.
How can I send it back? Asking them to condone the deal.
because there is no reasoning as such, my lord.
September 9, 20. Wouldn't clear.
No, it's on merits. Page 54. Para 2. Second para.
The type copy is at page 50.
Page?
50 is a type copy, my lord.
Page 50.
They say that appeal was filed after the statutory period, so appeal is not admitted.
See, the fourth para from the bottom.
Time barred,
No, above that.
due procedure has been followed. Then let it come up on a date, my lord, because I can also argue on the points of merit, my lord. I have good grounds on the point of merit.
See, I therefore do not find any merit in the appeal. He has gone into the merit. Do not
Yes.
find any merit in the appeal. The appellant being a member of disciplinary force deserves no interference in the order passed by the disciplinary authority.
Further, he has appealed in only on 6/11/19 after
Of
long
course,
gap.
that is another inclusion. But then he has, of course, he has not given reasons why he
Delay, yeah.
agrees with the findings of the disciplinary authority. He just said you are of the discipline force. So it's up to you. Maybe it may not be proper to send it back.
Then I can argue on merits on the next date. Because there's no reasoning as such why the delay, because they passed the order and there's no reasoning as regards my delay condonation application, my lord. Because it was accompanied with a delay
No,
condonation.
they have stated here. He preferred his appeal only on 16 November 2019 after a long gap without indicating any reason for the delay.
No,
There was no reason, that's why, my lord, they have did not, my lord, accept it. Appeal.
the application was filed, my lord. At page 42, this is my delay condonation application.
Condonation made me, my lord, but that was not accepted. I'm confused.
It is not that I have not explained my delay.
Okay, we'll see. But yes, learner counsel for the petitioner. You want some time?
That is, my lord, next week.
Okay, on request made by Mr. T.C. Chutial and additional senior governor. Okay. Please the matter when?
After 2 weeks, my lord.
Can it be on 14 March, my lord?
14 March.
On 14th March.
March obliging.